Var mı şimdi? Olmaması lazım da bir bak bakalım. Yok mu? Tamam. Bir saniye gönderiyorum sana hemen.
Evet, başlamaya hazır mıyız acaba?
2, 3, 4, 5. Ses deneme, ses kontrol. Say, hey.
How do I
Ses deneme,
pronounce
ses
that?
kontrol. 1, 2, 3, 4, 5 ses prova. Temiz mi?
Grain, I'm going to say, okay, McKeever. Okay.
Ses kontrol. 1, 2, 3, 4, 5 ses prova.
McKeever.
Ses deneme.
Stephanie.
Yeah, Stephanie is correct. Yeah.
Lemke.
Lemke, yeah.
You're German.
Yes, I'm
Oh,
German.
okay. I like German.
Ses deneme, ses kontrol.
In Turkey, you can't find people like me, but I learned first German
Oh, nice. You
in
went
the
to-
high school, like gymnasium,
Oh, nice.
and I had very many German teachers there. I really admire your language, and people in Turkey don't like it indeed. People think I'm weird, but I like it. I think that's the best language in the world. Sometimes I just read the sentences. How nice is this language?
Yeah, we have this very long word, but it's also quite poetic. Yeah, my friend I visited afterwards in Istanbul. He's Turkish as well, and he went to an Austrian school.
Yeah, it's very similar in Ankara.
Yeah,
Oh,
but
yeah.
it's funny because when he speaks, he
Who is
uses
that?
Austrian German. Oh, it's also a lawyer. We met in Cologne, actually. A good friend of mine.
Ah, okay. Ah, yeah, okay. It didn't work, sorry. Okay. Evet, tekrar hoş geldiniz. Bu oturumda ben planda yoktum aslında.
Well, I will only help the organizing of the session. There is an echo in the sound, which is continuing. I think this would be bad for YouTube as well. Shall I go? The echo is not over, but well, there are people who are hard of hearing and using gadgets. Aids. We cannot hear the speaker, so someone should warn her that her mic is not on.
Recording in progress.
We cannot hear the speaker.
Evet zannediyorum çevirmenlerin ilgili sıkıntı var. Ses gitmiyormuş onlara. Acaba çözebilir miyim?
I think the speaker has realized that we cannot hear her, so this is what she's saying, I think, because I heard the word interpreter. The problem has been solved. Now there's an echo, unfortunately, says the speaker. Says the moderator. Let me start out with a personal story. Being here at this session makes me very happy. In 2017, we established the legal clinics. I don't know why, but she's apologizing to the interpreters, but then she said there's an echo. Can we solve that? The interpreter can hear, but there is an echo. Not for us, but for her. Can we try the hand mic? Well, now it's better. Now it's better. I do believe that we will do with this, be able to do this. When we established the legal clinic, Kıvılcım and Kasım Akbaş gave me a helping hand. The apology was for the Turkish special expression. Now, we will be starting now with the strengthening access to justice, that session. And the topic we're going to talk about is the role of legal education in access to justice. Dr. Kıvılcım Turanlı helped us very much with the legal clinics. She prepared many reports on the question. She has very important translations. Now I leave the floor to her. Can you hear me? Yes, we can. Well, we can't. We can't. Unfortunately, this is not transmitted to the interpreter's booth. Not transmitted to the interpreter's booth, so we cannot translate. So someone should stop the, tell the moderator. Unfortunately, we cannot translate because we're not being transmitted the, no. No, we're not being transmitted the sound, no. But this is not the method. We should be transmitted the sound directly into the booth, not raising the sound for the hall. That's not the solution. I think the moderator should stop the speaker for a moment.
Çok özür dileriz herkesten. Bir 5 dakikanızı rica edeceğiz. Gene denememiz gerekecek hocam ama yapabiliriz, evet. Kıvılcım Hoca'ya da söyleyelim. Evet.
Evet. Yani dün olan şey bugün niye olmuyor? Ben anlamadım ki.
Bir saniyenizi alabilir miyim arkadaşlar?
Tamam hocam, isterseniz. Hocam şöyle yapalım isterseniz. Çevirsiz yapalım.
Arkadaşlar bir yapalım, ondan sonra
Vahit Bey,
tartışırız.
biraz önce söyledim size ya, lütfen. Teknik aksaklık için hepinizden çok özür diliyoruz. İlk sunumu çevirisiz.
Well, this first presentation will be made without translation, so as not to lose time. Very precious time. After that, of course, we'll resume the translation simply because the problem arises from the Zoom system being used. Whatever system they're using for transmission online.
Deneme 1, 2, 3, 4, 5. Ses kontrol.
Sesim geldi mi?
Yalnız değiştirmediniz.
Geliyor hocam sizin sesiniz.
Tamam, süper.
Aksuki'ye şu anda gönderiyorum sana. Gelmiş olması lazım. Senin sesin açık şu anda. Ses kontrol. Ses deneme. Deneme 1, 2, 3, 4, 5. Ses kontrol. Alabildiniz mi?
Hocam bizi duyabiliyor musunuz? Kıvılcım hocam.
Ama hocanın sesi gitmiyor.
Az önce sana verdiğim kablo geliyor mu? Doğru yere bağladınız mı ses kartında? Açtım.
Tamam. Başlasın o zaman Kıvılcım hocam.
Buradan başlayacaklar değil mi? Salonun içinde devam ediyor.
Oradan başlayacak. Bizim sesimiz ona gitmeyecek.
Gitmeyecek. Tamam.
Duyulmamış olması riskine karşı tekrar teşekkürle başlayayım ben. Bu konferansı organize eden herkesin emeğine sağlık. Ve elbette çevirmenlerimize teşekkürler. Bu arada az önce unuttum, Çiğdem tanıtım için de teşekkür ediyorum. Sağ olasın. Ve tabii siz katılımcılara da teşekkürlerimi sunuyorum. Şimdi az önce de yani bağlantı kopmadan önce başlamıştım. Benim sunum başlığım hukuk, adalet erişimci hukuk öğretiminin rolü. Çok kapsamlı bir mesele olduğunun farkındayım. O yüzden burada bütün bu sorunları tüketmek gibi bir iddiam yok. Ama biraz belki hukuk öğretimindeki sorunların bir kısmını ortaya koyup hukuk kliniklerinin de bu sorunları en azından azaltmaya yönelik ya da azaltmayı sağlayacak bir yöntem olup olamayacağını tartışmak. Öncelikli derdim bu ama hemen şeyi belirtmek istiyorum. Biz hukuk öğretiminde sorunlardan bahsederken Türkiye'de sanki bunları sadece biz yaşıyormuşuz gibi algılıyoruz. Oysa hukuk öğretimine ilişkin sorunlar dünyanın neredeyse her yerinde benzer. Hatta bazı ülkelerle bir araya geldiğimizde fark ediyoruz ki aynı sorunlarla uğraşıyoruz. Ve bu sorunları aslında konuşurken bir yandan da bulunduğumuz ülkelerin yargı sistemini, adalet sistemini, hukukun nasıl işlediğini, hukuki mekanizmaları konuşuyoruz. Ama aynı zamanda idari ve yasal süreçleri de konuşuyoruz. Çünkü hukukçular dünyanın hiçbir yerinde sadece hakimlik, savcılık ya da avukatlık yapmıyorlar. Çeşitli idari görevler alabiliyorlar, yasama görevleri olabiliyor ve elbette adli süreçlerin tamamında yer alıyorlar. Haliyle aslında hayatın her yerine dokunan bir meslek grubundan söz ediyoruz. Böyle olunca gerek uygulamada gerek öğretimde yaşanan sorunlar aslında bütün bir sistemi baştan sona etkiliyor. Ve bu bütün sistemi etkilemesi tek başına sorun olmayabilirdi eğer yaşantılara dokunmasaydı ama aynı zamanda yaşantılara dokunuyor. O yüzden önemli. Bundan beridir burada adli erişime ilişkin, adalete erişime ilişkin sıkıntılar üzerinde konuşuyoruz, çözüm önerileri üzerinde konuşuyoruz. Ama ben hukuk öğretiminin burada nasıl bir rolü olduğunu tartışmaya başlamadan önce esasında biraz şeyden de bahsetmek istiyorum. Dün Duygu Hatipoğlu çok net bir biçimde açıkladı, burada olanlar varsa hatırlarlar. Modern hukukun adaletle özdeşleştirilmesi. Dolayısıyla biz hukuku esasında genellikle sadece adaletle özdeşleştiriyoruz ve sanki kerameti kendinden menkul bir şeymiş muamelesi yapıyoruz ona. Sanki kendiliğinden adaleti sağlayacakmış gibi yaklaşıyoruz. Dolayısıyla aslında hukukçulara da böyle yaklaşıyoruz. O yüzden örneğin hukuk fakültelerinden ses gelmediğinde ya da hukukçulardan ses gelmediğinde herhangi bir sorun olduğunda hayal kırıklığıyla yaşıyoruz. Çünkü dedim ya kendiliğinden olacakmış gibi bir insanın hukuk fakültesi mezunu olması kendiliğinden insan haklarından taraf, kendiliğinden ayrımcılık karşıtı, kendiliğinden eşitlikçi yapacakmış gibi bir algıya sahip olabiliyoruz. Oysa genel anlamıyla eşitlikçi olduğu algısı biraz sıkıntılı. Yine dün Duygu Hatipoğlu ve Yasemin Öza esasında bunu çok net ortaya koydular. Cinsiyetçi boyutuyla ortaya koydular. Ama adalete erişim dediğimizde esasında biz erişemeyenlerden bahsediyoruz. Ve kimler erişemiyor? Elbette dezavantajlı gruplar, kırılgan gruplar, ötekileştirilenler, marjinalleştirilenler. Şimdi buradan baktığımızda hukuk esasında mevcut yapıyı koruma iddiasında olduğu için muhafazakar bir kere. Yani hukuka ilişkin tespitlerimizle başlamak gerekiyor. Sınıf ilişkilerini düzenleme anlamında kapitalist, ikili cinsiyet normlarına dayandığı için cinsiyetçi, çocukları ve yaşlıları görmediği için, onların sorunlarının farkında olmadığı için yaşçı, aynı zamanda sağlamcı. Bu örnekler elbette çoğaltılıyor. bir öğretme yöntemi. Ve başlıca 2 metodu var. Belki bu metodlar üzerinden gidersek biraz daha açıklayıcı olacaktır. Birisi Street Law denilen gündelik hayatta hukuk klinikleri, birisi de gerçek müvekkil klinikleri. Ama bunun çeşitlemeleri var. Çünkü ihtiyaca göre farklı farklı hukuk klinikleri de kuruldu ülkelerde ve kurulmaya da devam ediyor. Ne yapılıyor burada? Adalete erişemeyen dezavantajlı grupların adalete erişmelerini sağlamak üzere hukuk fakültesi öğrencileri, barolar, hukuk fakültesi öğretim üyeleri ve yereldeki diğer kurumlarla işbirliği içerisinde bir takım sistemler kuruluyor. Örneğin gündelik hayatta hukuk kliniğinde hukuk fakültesi öğrencileri sorun yaşayan gruplarla ya da adalete erişemeyen gruplara gidip onlara hak eğitimi veriyor ya da onlara haklarını anlatıyor. Lise öğrencileri olabilir, kadın merkezleri olabilir, çocuklarla çalışmaları olabilir, LGBTİ'lerle çalışmaları olabilir ama her durumda ihtiyaç sahiplerine, ihtiyaç duyulan mesele üzerinde hak eğitimi veriyor. Ve bunu yapanlar hukuk fakültesi öğrencileri oluyorlar ve tıpkı derslerinde kendilerinin öğrendikleri gibi interaktif yöntemlerle yani ihtiyaç duyan hedef kitleyi de dahil edecek biçimde bir öğretme metodu geliştiriyorlar öğretim üyelerinin gözetiminde. Gerçek müvekkil klinikleri ya da bizim Anadolu Üniversitesi'nde kurduğumuz adıyla yurttaş kliniklerinde normal koşullarda özellikle maddi problemleri nedeniyle adalete erişemeyecek dezavantajlı gruplara hukuki bilgi veriliyor. Yaşadıkları hukuki sorun hakkında bilgi veriliyor hukuk fakültesi öğrencileri tarafından. Bu bir Anglo-Sakson sistemi. Anglo-Sakson ülkelerinde
Now we can.
Yani gerçekten müvekkilleriymiş gibi mahkeme önünde temsil de edebiliyorlar. Zaten hukuk kliniklerinin geçmişine baktığımızda özellikle Amerika ve Güney Afrika'da başladığını, öncülerinin onlar olduğunu ve sonra bütün dünyaya yayıldığını görüyoruz. Bu arada her iki dediğim gibi başlıca klinik türleri bunlar ama en temelindeki dert normal koşullarda kendi hayat koşulları içerisinde adalete erişemeyecek olan insanların adalete erişmelerini sağlamak. Burada önemli hususlardan birisi az önce dedim ya biz hukukçudan örneğin hukuki araştırma bekliyoruz. Evet gerçek müvekkil kliniklerinde ya da yurttaş kliniklerinde olan bu. Gerçek bir sorun üzerinden çalışıyor öğrenciler ve gerçek insanlarla karşı karşıya geliyorlar. Kısa süren klinik deneyimimizde biz bu gerçek insanlarla karşılaşmanın esasında ne kadar önemli olduğunu gördük. Çünkü dosya olmaktan çıkıyor sorunun tarafları. Canlı insanlar olduğunun farkına varıyor üniversite öğrencileri ve bu önemli bir kazanım olarak döndü. Yine Türkiye'de ve dünyada esasında adalet erişiminin önündeki en büyük engellerden birisi hukuki bilgiye ulaşmanın zorluğu. Çünkü hukukun kendine özgü bir tanrısı var. Hukuki bilgi çok da paylaşılan bir şey olmayabiliyor. Özellikle otoriter rejimlerde çok da halkın bilmesi istenen bir şey olmayabiliyor. Hukuk dilinin resmi dili olması, dilleri başka olanların adalete erişimini güçleştiriyor. Örneğin tam da bu noktalarda gündelik hayatta hukuk kliniklerinin çok yararlı olduğunu görüyoruz. Çünkü ihtiyaç duyanlara hakları hakkında bilgilendirme yapılıyor. Şöyle bir örnek vereceğim. Dünden beri adli yardım üzerine konuşuyoruz. Bugün de konuşulmaya devam edilecek. Anadolu Üniversitesi Hukuk Fakültesi öğrencileri kadın merkezlerine gittiklerinde elde ettikleri ilk veri şuydu. Kadınların çoğunun adli yardımdan haberi bile yoktu. Bakın bu kadar temel bir bilgiye ulaşma halinden söz ediyorum. Yani usulden, izlenecek yöntemlerden filan değil. Böyle bir bilgileri yoktu. Şimdi sadece bu bilgiye sahip olmanın bile insanları ne kadar güçlendirebileceğini zihnimizin bir kenarında tutmak gerekiyor. Bir takım yine özellikle otoriter rejimlerin olduğu ülkelerde, dediğim gibi klinikler dünyanın her yerinde var. Bilgi edinme klinikleri var. Türkiye benzeri örneğin kentsel dönüşüm benzeri uygulamalarla yerlerinden edilenler tam da bu bilgi edinme klinikleri sayesinde hukuk fakültesi öğrencileriyle birlikte aslında haklarının farkına varmışlar. Çarpıcı örneklerden birisi, bizim karşılaştığımız çarpıcı örneklerden birisi Kenya örneğiydi. Birleşmiş Milletler ülkeye ilkokulların yapılması için ciddi bir ödenek ayırıyor ve bu ödenek kullanılıyor bir şekilde. Ama okullar şöyle yapılmış, işte bir köyde okul binası yapılmış, camları takılmamış, bir köyde yapılmış, sıraları işte konmamış vesaire. Ve hukuk fakültesi öğrencileri şunu başlatıyorlar, okulum nerede? Tam da bilgi edinme kapsamında bunu başlatıyorlar ve sorular sormaya başlıyorlar. Bu para nereye harcandı? Buraya okul yapılması gerekiyordu gibi. Bu örnekleri şunun için veriyorum. Öğrencileri ne kadar erken gerçek sorunlarla karşılaştırırsak esasında hem düşünme becerileri hem de o biraz önce saydığım hukuki analiz, hukuki araştırma, etik ikilemler arasında seçim yapabilme ve çözüme ulaştırma gibi yetenekleri de affedersiniz, o kadar gelişiyor. Bunun yanı sıra uygulanan başka yöntemler de var. Örneğin yasama klinikleri var. Halkın yasa teklifinde bulunabildiği yerlerde hukuk fakültesi öğrencileri bir yasa teklifi hazırlayabiliyorlar ihtiyaç sahipleriyle birlikte. Çiğdem'in yürüttüğü klinik var. Belki o biraz söz eder. Ombudsman dostu klinik. Birlikte karar yazıyorlar. Kurumla birlikte karar yazıyorlar öğrenci. Dolayısıyla az önce bahsettiğimiz o iletişimin yazılı kısmında aktif olarak rol alabiliyorlar ve dertlerini yazılı olarak anlatmayı öğrenebiliyorlar. Ve bunu aslında mesleki hayatlarına da taşıyorlar. Gündelik hayatta hukuk klinikleriyle sözlü iletişim becerilerini geliştiriyorlar ve daha önemlisi anlatılan bir sorunu hukuki bir biçimde formüle etmeyi ama aynı zamanda hukuk jargonu dışında yani gündelik dille karşılarındaki insana aktarmayı da öğreniyorlar. Dolayısıyla iletişim becerileri de güçleniyor öğrencilerin. Türkiye'de uygulanan başka örnekler de var. Mood court'lar örneğin, işte simülasyon klinikleri var. Ama burada önemli olan ya da kliniklere ilişkin esasında göze çarpan hususlardan birisi hukuk fakültesiyle yerelin işbirliği kurmak zorunda kalması. Yani barolarla hukuk fakülteleri arasında işbirliği başlıyor, yerelle başlıyor, belediyelerle başlıyor. Eğer lise öğrencilerine hak eğitimleri veriliyorsa eğitim kurumlarıyla başlıyor. Ve bunların hepsi bir yandan yereldeki sorunların da belirlenmesini sağlıyor. Yine deneyimden bir örnek vermem gerekirse, biz en çok kadına şiddete ilişkin hak bilgilendirmeleri yapmaya çalışırken üniversitede çalışan dönemin işçi kadınları biz bunu istemiyoruz, biz sendikal haklarımızı öğrenmek istiyoruz demişlerdi. Dolayısıyla ihtiyacın yerinde tespit edilmesini de sağlıyor hukuk kliniği uygulamaları. Çünkü hukuk fakültesi öğrencileri yerinin ihtiyaçlarıyla hemhal olmaya başlıyor. Elbette bunların hepsi yöntemler ve ihtiyaçlara göre şekilleniyor. Bazı durumlarda bürokratik engellere göre o engelleri aşacak uygulamaların kurulması gerekiyor. Bunların hepsi çözümler dahilinde. Şunu iddia etmiyorum, hukuk öğretimindeki sorunları klinik tek başına çözecek diye. Böyle bir şey mümkün değil. Yani böyle bir sihirli değnek yok. Ama belki daha sonra sorularla ya da salondan katkılarla bunu geliştirebiliriz. Bu mevcut yapısal eşitsizliklerle mücadelenin bir yolu olabilir. Çünkü sadece teknik bilgi anlamında değil, değerler anlamında da öğrenciler çok erken başlıyorlar. Özellikle o etik ikilemler arasında seçim yapma, haktan yana olma. Çünkü biz en nihayetinde şunu bekliyoruz mezun olan öğrencilerden. İnsan haklarından taraf olmalarını, tarafsız olmalarını falan değil. Ayrımcılık karşıtı olmalarını. Bunu yapabilecek yollardan birisi ise daha da çoğaltılması gerektiğini. Çünkü Türkiye'deki hukuk klinikleri var ama düşündüğümüz ya da umduğumuz kadar çok sayıda değil. Ve aslında dünyada ne olup bitiyor onu da görerek, onu da gören bir yerden işbirliği içinde yürütülmesi gerektiğini düşünüyorum. Dediğim gibi tek çözüm değil, bir sihirli değnek değil ama denenmesi gereken yollardan birisi.
Geliyor. Gelmiyor ki. Gelmiyor.
hukuk kliniklerinin ve pro bono ağ kurulmasının öncülüğünü yaptı. Dersler verdi ve vatandaşlarla yargının ilişkisiyle ilgili birçok araştırmada yer aldı. Cezaevlerinde sorun...
At the same time, she is interested in areas outside of law. She did her PhD in political science. And before the Me Too movement, she worked on sexual harassment in Turkey under the title You Go Ahead and Tell Your Story. And she's working on a podcast on this issue. And she's a researcher at the London School of Economics. I leave the floor to her now. Thank you very much. Because I'm a hyperactive, I cannot speak while sitting. Can you please turn on the PowerPoint presentation? I had sent you that before. I'll be very happy if you can. Well, since yesterday we have been discussing many important things, and Professor Kıvılcım also talked about this, some related things. Yesterday, Ulaş talked about the research that we're doing, which is on Justice Stand. The speaker is trying to cope with technical problems. Yes, now we can. Well, watch out for justice is the title of the research. If we try to translate the rhyming two words. These are the questions that we asked people regarding law, the wrong answers. At the top, 30% of the citizens of Turkey think that Turkey has a jury system. Some people think that you cannot file a case without a lawyer, and this is all the way up to 54%. So there is almost no information or great lack of information on the part of the people with respect to the functioning of law, the legal system in Turkey. On the other hand, we should say the following: although we think that the information of the people in general is very low with regard to law, at the same time, starting in the 1990s, one can say that people's interest in law is increasing, because, you know, we even heard people yelling on the street, injustice is being done to me, I'll go to the European Court of Human Rights. So, why did we feel the need to teach law through a podcast? As was said before, in prisons and in classes, I was teaching through legal clinics. My students went to prisons for 9 weeks on end and tried their hand at teaching law to prisoners. in order to increase the level of awareness, and I was able to see how that increased the level of awareness of the prisoners and how that helped my students. Ulla Ashton said this yesterday. People don't need to go to court in order to seek justice. They don't need to go to lawyers. This was one of the things that was said yesterday. Access to justice cannot be reduced to access to courts. People should be conscious of their rights and be able to pursue the acquisition of those rights. So this level of information is lacking in Turkey. Ulaş emphasized this yesterday. In Britain, at least, there is the Citizens Advice Bureau, which helps as an intermediary organism in order to help citizens to seek their rights in certain public administration institutions. People cannot even fill in marriage forms in Turkey. People need help to fill in those forms. So what do you need? You need your father's name, mother's name, date of birth, etc. Where were you born, etc. That kind of question. And so people need to make a jump forward, a leap forward, in order to understand the nature of law. Kıvılcım said this as well. What we are trying to do through these legal clinics is to use students as an intermediary to take to people the fundamental concepts of law. But under the pandemic, it was impossible to reach out to these people. So I said to myself, I cannot give the students this opportunity under the pandemic. What can I do? So I can perhaps make a podcast of a legal clinic. Well, we did this in the Van earthquake. When the earthquake occurred, people lose their ID cards, their title deeds for their houses, etc., etc. So they need help. So under the pandemic, what are the legal questions that arise, and what kind of information do people need for this? We started to work on this, and then now I will play for you a trainer who speaks for 2 minutes, and we took up one of 8 topics in these podcasts. I do the opening. I had only 5 students. They give small quotations, brief quotations about certain topics. Please pay attention to how they use their voice and all that, because some are better, some are worse. We'll talk about that. I do hope that we can hear this through the system. I will turn up this volume all the way up. The Legal Clinic podcast is used for transmitting information to people under the conditions of the pandemic. You need to pay the loan that you have received because the state won't pay it, and so you can only postpone it, or you may ask for restructuring. The employer cannot lay you off by showing that you, as evidence that you're ill. Some employers deposit in the bank the salary as if it were the minimum wage, but then receive part of it from the workers in person, and then you can go to court for this difference. There are different time periods, intervals for making applications for this kind of thing. Because deaths have increased, firms have raised their prices. If this is exorbitant, then consumers can make their complaints through the internet, through the system that has been established for this kind of grievance voicing. You can reach the Legal Clinic podcast through Anchor or Spotify. These are quotations from different programs. I wanted you to listen to these because there are some subtleties for preparing a podcast, because if some of you in the future wish to establish this kind of podcast clinic, then a cover photograph is very important. You see our pictures there, the 5 students and myself. Well, a very, very simple technique. As Kıvılcım said, the times have changed. There are many lawyers here, and to your client, if the lawyer does not answer the client in a short period of time, there are of course time intervals given for legal applications. So this is not really appropriate. This is not a matter of presenting a course through Zoom. Podcast is a sound block. We call the sound version of any presentation on the internet a podcast. You have to, of course, record the sound first, and then you have to edit it for ahs and ums and etc., etc., and you make it, something that is worth listening to. Well, we're talking about a program which is like a radio show, but radio shows are listened to at a certain moment. Podcasts are so good because while you're doing a kind of walking around or going to the metro or going shopping, you can listen to it. Certain law firms are preparing podcasts, but a technological product is not easy to produce. You can see my students there, but we have to work on many things. Well, the technology really disillusioned me in certain ways. Let me talk about my own technological adventure. In order to do this kind of thing in a bar association, at the university, etc., you need certain technological preconditions. But technological possibilities change very rapidly, and if you're not ahead of it, then you lose some possibilities. Some then change again, and you have to start from zero again. I was on Twitter for a very long time, and Çiğdem said it. Where did I get the other name? She first misnamed Çiğdem. I wrote a travel blog for a long time. I was on Instagram, on YouTube, etc. But if you want to make it something that people would like to listen to, it's not that easy. You say, I'm part of this, but then story starts in Instagram. You say, I'll watch this tomorrow, but in 24 hours that story is gone. So you need to show some interest in technological aspects. This I realized I could only do after I left Bilgi University. I had so much to do. I was busy monitoring my students' activities in the prisons, etc. When I did focus on, the technological aspects, then I was able to do the podcast. What video and podcast? I will talk about that too. Well, Kıvılcım Hoca said this as well. Wishes, aims to offer students certain professional skills. What kind of skills? It's not a matter of, certain articles, of certain laws, numbers such and such, and dates such and such. Without using these, it's possible to teach people what their legal rights are. To prepare a podcast has to do with the voice. If you talk like this, nobody will listen to. If you do then no one will listen either. But no one will listen, as I said. But so it depends on your voice, and you have to be self-conscious about how you're speaking. It's not a matter of, you're writing a book. You're addressing a crowd, and you have to be able to speak like these anchors on television. And so you learn this. You are now even aware of your pronunciation or the way you speak. We always gave feedback to students. Well, sometimes they mispronounce the words. Some of us, have really difficulty in saying certain words, so we pointed this out. When you're recording something, we found out that the quality of the sound is very important. There should be no call to prayer. There should be no sirens going on in the streets, etc., etc. You can't even imagine these things before you start doing this thing. And this kind of thing is a sabotage for preparing a podcast. Or someone opens the door and yells to you, whatever. Even the whispering is, heard on the podcast. So their self-consciousness with respect to their voice, with respect to the pronunciation, etc., etc., have to be worked on. How many people listen to podcasts here? Well, it's not so too many, but there is a certain amount of people who listen to podcasts. I asked the students, what do you like these? Do you like the jingles? Do you like the woman's voice? Or do you like the man's voice? It's whatever you like, you may imitate. There's something very important here. Law is difficult and complex. You can only explain this through your voice. Other visual effects do not really transmit the idea. So the quality of your voice should be very good. You have to work on it. Then we worked on free podcasts and software, etc., etc. Well, two students said to each other, Duygu, what are you going to tell us about workers' rights today? I had cancer, and because of the pandemic, they asked me for my cancer tests. Okay, is this possible? For them to do? No, of course not, says Gökçe. So you find out the difference between the different performances. And I said to the students, we're doing all this, but in order to see the relationship of the people to law, let's go out on the street. Well, you speak from behind the mask under the pandemic, and then it's difficult, of course, but this is another way. What kind of topics did we take up? I have a COVID test every fortnight, and I'm asked to share my blood test values with human resources. Do they have the right to share this confidential, to have access to this confidential kind of information? Well, I was using a toothpick, and because of this, I wasn't wearing a mask, and then the police officer came up to me and fined me for this. Is this just a fair thing to do? I did, have a police officer intervene with me and fine me, and I really had it cancelled. But that's, a personal thing. Well, you heard this on the podcast. A wage level that was below the minimum wage was offered to me. Well, I'm for freedoms. I don't want to have a jab. Can I have 3 more minutes? My COVID test was positive. The employer said the test was negative, but don't come to work. You don't need to go to court. You don't have to file a suit. Well, I have a loan to pay, and I was laid off. Can I have any facilities from the bank? Well, everyone pays their debt, and so you're not. You have to find jingles. One of the students really solved this problem very well. There are many unpaid jingles. And many people use these. Then there has to be an opening announcement. You heard it at the beginning. This is done by the students of big university. There is a closing announcement as well. Let me read it to you. This aims to provide general information. For specific information, you need to consult a lawyer. If you don't have if you can't pay the fees of a lawyer, then go to the Bar Association of your province, where you can receive unpaid legal aid. So, we're not really out there to provide answers to all questions. So we also advise them to go for legal aid. There were 9 sections. Spotify or Anchor are the channels through which you can listen to these. Oh, Legal Clinic podcast. How can we really measure its success? Is it because it has reached more a greater number of people, or is it because students are happy with what they've done? Because I taught a course on legal clinics for years, I think in the following manner. A teaching institution cannot teach the masses. It can really educate its students, but we need to serve the people as well. The podcast is a very good opportunity, provides a very good opportunity for reaching out to the masses. But of course, a smartphone or a laptop are necessary, and how many people can really have access to this? Scavengers on the street, can they really have access to this kind of information? And well, we have to formulate these questions. Of course, podcast has helped certain people, perhaps not the most disadvantaged people. We don't need to reach out to the lowest level in order to be useful to the people at large. Let me show you something. I want to show this to you. Spotify has a function which it has statistical data which it shares with us. How many times have these podcasts been listened to? The part that has been listened to most often is the legal consequences of COVID. Then, secondly, what kind of impact will this have on loans you've received from banks? The rights at the workplace. What can I do with respect to fines due to COVID, bans? I was, these were the most popular ones. I was very surprised. At the beginning, there was no one listening to us, but we had 100 followers 1 year later. This is not very high, but some people were following us. Of course, you have to increase. In order to increase the number of your followers, you need to do something every week. These are young people. 18 to 22, that age group is more than 50%, and 60% are women. Perhaps things that you have to keep in mind while doing a podcast, perhaps, is to develop an instrument which can measure your success. Thank you for your patience.
Thank you very much. This was a general presentation about the clinics and a special presentation about the use of podcasts. Our next speaker, will be talking about law technology and best practices from Europe. And if I am to introduce her briefly, it won't be very short. She is a lawyer and she has been working in the area of law reforms in the last 15 years, and she has worked in different law firms and international agencies in Europe, Southeast Asia, and Latin America. She used with UNDP as a legal aid expert, and she finished her PhD in Oxford, and she worked she also studied in Germany, and in front of the criminal courts, she had important cases, and also she was given the task to prepare the first legislations, and by the European Commission, there were expert committees assigned, appointed, and she was a member, and services to disadvantaged groups is another area that she is interested in. Yes, the floor is yours.
Much, Professor Sever, for your kind introduction. So, distinguished participants and guests, it is an honor for me to participate in the International Conference on Access to Justice, and a great pleasure to be back in Ankara. I would also like to congratulate the organizers in putting together such a practical and thoughtful program. Today I want to share with you some insights into my work on legal aid and my role of legal aid specialist for UNDP, and having drafted Europe's first guidelines on legal aid for the Council of Europe. And particularly, I want to look with you at the role of legal technology to facilitate access to justice for disadvantaged groups. And in my presentation, I will outline some of the key challenges, key challenges of disadvantaged groups they are encountered when accessing legal aid services. And also, I will look at you with global trends, good examples of good global trends, good examples of practice of countries in Asia and Europe where IT solutions are used to make legal aid services more accessible to all people. So in 2013, the UN Special Rapporteur on the independence of judges and lawyers warned that countries need to develop and sustain an effective legal aid system as an essential component of a fair and efficient justice system founded on the rule of law. Legal problems left unaddressed can severely impact people's livelihood. And this is why in many countries, governments develop legal aid programs to raise awareness of people's rights and to assist people to resolve their legal disputes. Legal aid programs can help to make the voices of people heard, to defend their right, and also to close the justice gap between those who can afford to pay for a lawyer and those who cannot. And key to a functioning legal aid system is to make legal aid services accessible to all people. And this means that governments need to have in place a legal aid system that raises awareness of people's rights, and that makes also clear that a legal aid is available to people. This is a very, very important point. And in practice, there are many measures and policies to assist governments to have actually, to provide such information to people. One is to have a simple and straightforward procedure in place to apply for legal aid, also a sufficient number of legal aid providers, lawyers and local authorities that provide those services to people. Then also that those legal aid advisors spread evenly across the country, that information about legal aid is provided in a way that that people are aware that legal aid is available to them. And also it is very important that this information is provided in a manner that is clear and understandable for everyone. In other words, people should exactly know where to go when they have a legal issue, and also what kind of information is provided to them, and if needed, where further information can be obtained. In practice, however, I observed through surveys and interviews I conducted with a wide range of stakeholders across Asia and Europe that in particular disadvantaged groups face many challenges when accessing legal aid services. And this includes, for instance, that disadvantaged groups, they are not even aware of their rights or their right to legal aid because the communication channels used to reach them are ineffective. Disadvantaged groups also have difficulties to access legal aid services because there are physical and psychological barriers that keep them from the system. For instance, legal aid advice centers are not physically accessible because they have no lift, or legal aid services are not provided in remote areas. Respondents also shared with me that in some countries, there's also a trust issue. Legal aid stakeholders, local authorities, and lawyers are not sensitized to the needs of disadvantaged groups. For instance, providers are seen as not approachable and not trustworthy because they do not sufficiently address or overlook the needs of disadvantaged groups. For instance, the specific needs of women who are victims of domestic violence. Another issue is that legal aid providers do not cooperate with each other. Providers do not know of each other's services. For instance, yesterday we heard a very important presentation about social workers. Some providers don't know about social workers or victim support organizations that could actually help in such situation where they have no idea how to talk, what kind of advice to give to people, in particular to disadvantaged groups. And finally, what is very important also to point out, many disadvantaged groups also feel troubled, challenged when generally accessing, and having this complexity of formal legal systems. They feel overwhelmed by how complex and also how time-consuming it can be to apply for legal aid, with disadvantaged groups being asked in many countries to verify their eligibility for legal aid through additional documentation, for instance, proven that they have to give proof that they are a victim of human trafficking. So as you can see, disadvantaged groups face many challenges when accessing legal aid services. Their needs are failed. They do not know of their rights and their right to legal aid. They do not get the help they need, and as a consequence of this, they question the quality of service. And at the same time, shortage of legal aid funds has made it even more difficult for people, in particular also for disadvantaged groups, to access legal aid services. In many countries, there were shortages of legal aid funds. These cuts meant that people have no access to justice anymore, with certain types of cases being completely dropped from the national legal aid schemes, meaning that people have to represent themselves in the court without any legal assistance. And in this context, IT solutions could have many advantages. IT solutions can help people to navigate through a legal system, increasing the visibility, the understanding, and also the accessibility of legal aid services, and avoid time-consuming and costly court proceedings. IT solutions can allow governments to empower and support people who otherwise wouldn't obtain certain information. They can respond quickly to a large number of people, and they can also prevent, by helping the cost of legal aid from spiraling, by helping people at the earliest stage possible of legal court proceedings. In the following, I would like to show you a couple of examples. I will start in Europe. It is a chatbot in Belgium. It has been developed. It is used to let people navigate through the legal aid system in Belgium. It answers to simple questions. It determines if you're eligible for legal aid or not. And also it tells you what kind of information you need to apply for legal aid. And it also tells you if you're not eligible for legal aid, it redirects you to the Bar Association's homepage, where you can access information of a lawyer who's close by, depending on your location and also the legal issue concerned. And I would also like to introduce you to some very interesting, good examples of practice from Asia. In Asia, in particular, hard to reach communities are informed of legal aid by using mobile phone applications. In Indonesia, for instance, there are people are connected with a lawyer through an online registration desk, depending on their location and also the substantive nature of the case. In the Philippines, and this is something you can see here, there was an online platform developed. It's called Legal Tree, and it helps also to match people with a lawyer. In the Philippines, the problem is that 80% of people who seek legal assistance, they do not have access to such assistance. This is really a problem. This is because there's only one lawyer for every 2,200 people, where the optimum number would be one lawyer for every 250 people. LegalTree works together with more than 100 lawyers across the Philippines, and you can ask a question through its Ask Your Attorney function of this platform. And LegalTree will then, within 2 days, select a suitable lawyer for you from its directory of partner lawyers, depending on your location and also the specialization of the lawyer. And the lawyer will then reach out to you by phone or by video conference call. There are also 3 other examples I would like to share with you. One is in Cambodia. In Cambodia, there is an app called iConnect Justice, where specifically trained lawyers provide legal aid services free of charge to vulnerable people. In Vietnam, you have an app called D-Law. D-Law was created by a disability rights NGO, and it aims at people with disabilities, connecting them with a lawyer, because usually people with disabilities are failed by usual communication channels. This app also connects people with the NGO's website and its Facebook page, where you can obtain further information which could be relevant for your inquiries. Also, not also to mention in the last one in Indonesia, where a similar app has been developed for victims of domestic violence to get in touch with a lawyer. Come now back to Europe. Also, one very important practice I would like to share with you is an online database called WikiLegalAid, and this is for legal aid staff to ensure the quality of the legal aid service. Advisors can, through this database, access free documents, sample documents, like, so, for instance, how to make a referral to a victim support organization. Also, they can access case law, and also they have answers to the most common questions asked by visitors of legal aid advice centers. This app is regularly updated, and also all legal aid staff will make sure they all know about WikiLegalAid, how it works, through training sessions which are organized. And then my final example is from the Netherlands. That is a Rechtswijzer. It's a website funded by the Dutch government, and it helps people to navigate through their legal problems through this website. It includes a lot of self-help tools. And it has a decision tree which lists the most recurring legal issues in the lives of Dutch people, for instance, housing law, consumer matters, divorce, etc. So what it provides the people is that they can download free of charge documents, for instance, how to complain to your landlord. Then there's also an opportunity to create an action plan. So what kind of steps could you take to solve your legal issue? And also it advises you when you should actually seek the help of a lawyer. And it also gives you the opportunity, if you want a divorce, you can also do this online via an impartial third party in an online trialogue, it is called. This website also has displays a number of addresses of non-legal services, such as psychological support services. So to come to an end to my presentation, so effective access to justice means that everyone, without discrimination, should have the right to be provided with a system for conflict resolution and restoration of rights. This means that individuals and groups need to know about their rights in order to understand that they have been wronged in some way, and also to understand to what kind of protection they are entitled to. And in my presentation, I've shown you that in particular disadvantaged groups struggle to have access to justice, and in particular struggle to have access to legal aid services. And in this context, IT solutions could be an interesting way of organizing legal aid, particularly also to make legal aid services more accessible. IT solutions can increase the level of awareness of legal aid services. They can also improve the cooperation between different stakeholders to get people the help they really need. They can also help people to, for instance, to be more supported, to be more important, getting quickly, prompt and easy access to the help they need through online, through IT solutions. And finally, they can also help to keep a legal aid system sustainable. Thank you so much. I look forward to your questions.
Evet, zamanlama için ayrıca ben teşekkür ediyorum.
The time. Our last speaker, Ezgi Özlü. The title of her paper is Access to Justice by Disadvantaged Groups, an Evaluation of the Strasbourg Court's Legal Aid Practice. Ezgi Özlü is a research fellow at the Max Planck Institute, Luxembourg, Department of International Law and Dispute Resolution, and a PhD candidate at the University of Strasbourg. Her research focuses on how the European Court of Human Rights practice on procedural costs affects the nature of cases brought before its premises. Before joining the Max Planck Institute, she worked as a consultant at the Department for the Execution of Judgments at the European Court of Human Rights and is a research and a teaching assistant in constitutional law, admitted to Istanbul Bar. She holds a law degree and 2 LLMs, one in public law and one in human rights law. Thank you very much for the introduction. Well, I have a PowerPoint presentation. Would you put that on, please? I think you can see it now, can you? Thank you. First of all, I would like to thank the organizers for this. As Professor Chidem said, I am a student, a PhD candidate, and I'm very happy to be at this conference, and exchange of information has been very advantageous for me. At the Strasbourg University, where I'm doing my PhD, and the Max Planck Institute have gracefully allowed me to make a presentation here. I will be talking about the Strasbourg Court to you. Well, Stefania Lemka gave us a lot of information on this question, and yesterday Professor Matt talked about this and cited many examples from the Constitutional Court and the jurisprudence of the European Court of Human Rights and other constitutional courts. Now I'm going to be talking about the practice of the Strasbourg Court with respect to legal aid. You see here the plan of my presentation. There will be a small introduction. There will be some information about the background and the current situation. Then there is a question of research, and then I will come to my conclusion. I will be trying to limit my presentation to 15 minutes. There are very many different professions here, of course, but there are many lawyers. How many people know what the Strasbourg Court is? Well, not bad at all. The European Convention of Human Rights, Article 31, arranges for individual petition. Real persons or NGOs can claim violation of their rights and go to the Strasbourg Court. Is there any legal fee for doing this? There is none. Well, in the Constitutional Court, as Professor Matt said, there is a legal fee. There are legal fees, but not here. This access to the court, is this without any costs? No. Because, as you know, in order to have access to this court, according to Article 35 of the Convention, you have to exhaust the domestic remedies. You have to go through the different levels of domestic remedies. According to Article 36, paragraph 2, at the level of the communication, the applicant has to have representation. That's to say, there's lawyers' fees. As a rule, the communication should be sent in 2 languages, French and English. Of course, there are exceptions to this. Usually, you have to send this through mail and also all kinds of correspondence as well. Although this is exceptional, especially this happens in Grand Chamber level, there are sessions. So there is lawyers' fees, translation fees, mail expenditure, and sometimes travel and accommodation, which are necessary if there are sessions. There is a legal aid mechanism here. In the statutes of the court, Article 13 stipulates for this. Here, the objective is to meet the fees necessary. Well, there are some doctrinal there's some more doctrinal work with respect to domestic functioning of courts. There is only one piece of research that I know of, a research on the European system on this question done in 2002. This is what I am working on. My work is the access to justice disadvantaged groups with respect to the evaluation of to what level is the access to justice facilitated by the rules of the court's legal aid practice. During the convention, preparation of the convention, this was not discussed at all. When did it come about? In 1963. This was added to the bylaws of the Commission, not the court. Well, with respect to rules in bylaws and in many procedural rules, the court has a very high level of discretion with respect to legal aid. I am looking into this. This is very current. There are many discussions on the question of legal aid. Britain is a very important example. Everyone is looking at that as a role model, but the European Court is aiming for pro bono treatment. Now, this is met from the general budget of the Council of Europe. The scope of this budget from the 1990s on is being limited more and more, restricted, reduced more and more because of neoliberal attitudes. As you can see in the PowerPoint, I followed a certain method. I looked at the primary sources. You look at the European Council of Europe and its Committee of Ministers, and then I did some semi-structured interviews with certain people, the judges, the registry people, the jurists, that is, and comparative law also. Pursuing this method, I reached certain conclusions. The first conclusion is that by using this court, we said there's a high level of discretion. It restricts the legal aid. Once it does this, of course, it also limits the right to individual petition. And what are the consequences of this? First of all, I said the Strasbourg Court limits legal aid depending on its discretion. Well, first, there is the temporal aspect. This is done in a retroactive manner. That is to say, after the defender's state is notified. Therefore, the financial obligations of the pre-notification period really lies with the applicant. But here, this part is the highest part of costs incurred by the applicant. And the admissibility criteria of applications are being narrowed down, and the registry really interprets this in a very formalistic manner. The more refusals there are, the statistics look better, so they try their best to interpret this in the most rigid manner. So this should be prepared by an expert jurist, which would make it more easier to provide for admissibility. if this, and if an expert jurist prepares this, then of course those cases that are inadmissible will probably go less to the court. Then the scope is limited, because legal aid is limited to material aid, and the applicant has to find the ways itself. There was the Commission and the court up until 1998. In the past, they used to link up with the bar associations. From 1998 on, this was abandoned. When we look at comparative international law, other systems have disadvantages. For instance, there is a list of lawyers that you can go to, which makes things a bit easier. The same goes for the American Court of Human Rights. And finally, I would like to look at the limited amount of financial legal aid. 850 euros are granted for legal aid. This has never changed for the last 2 decades. And I calculated the real value of this 850 euros. In 2017, of course, the real value is much lower. This is not perhaps a problem for Turkey, but the residence of the applicant and his or her representative is not taken into consideration. Well, life is more expensive in a certain country, the thing is more disadvantageous. In complex cases, when I speak to lawyers, we work around 80 to 100 hours, so the legal aid that is provided is meaningless. So I think perhaps this should be indexed according to the level of purchasing power of the money in which the country, the currency of the country is valid. I did say that the legal aid is provided for by the budget. Is the insufficiency of the budget an explanation for this low level and limited nature of the legal aid? So if this is the case, we can expect for the budget to rise. I looked at the different items of the costs of the court. From 2015 on, this is like top secret. They never answered me up after 2015. We see the legal aid, share of legal aid within operational costs in graph 3. Costs have increased. Operational costs have also risen, but no rise in legal aid. Operational costs rise from 1987 to 1998. The legal aid, the share of legal aid within operational costs is reduced. After 1998, the share of legal aid rises, but then it made a peak in 1999 and then started to decline again. There is no parallel rise or fall between operational costs and legal aid, and in general, legal aid has the tendency to fall. So the question is not the budget. What is it? I invite you to think of this as an institutional policy. Perhaps the court can really do without the legal aid. As you know, the Council of Europe is in a process of endless reform. The number of individual petitions is way above the number that the court can cope with. They are reducing the staff of the court, but the expenses of the court are on the rise all the time, but this increase is not at the same pace as the number of individual petitions. Therefore, the court has to use its available resources in the most efficient manner. So it has to decide to do without certain things. One is legal aid. The Secretary General of the court says, Council of Europe says for 2003 and 2004 legal aid will increase, but this is not realized. There is a director of the registry of the court. This has not materialized. First of all, the amount of legal aid provided for the applicant is low. Secondly, the jurists in the registry apply very strict criteria for legal aid. Unfortunately, we don't know how many are admitted, how many are not. You can only see those that have been admitted. But the reason that we can conclude is that there is an effort on the part of the registry to restrict the amount of legal aid. And this is an institutional policy. You cannot explain this with the low number of cases opened. This always rises, so there is an institutional policy here. Last slide, before I finish my presentation, I would like to touch upon the probable consequences of this. Why is there legal aid? Professor Matt explained this. There may be many answers to this question, but really it has to do with the rule of law. This is a mechanism to make material, to make real the rule of law. People need legal aid. So without equal access to justice, this is not meaningful. So can we think of it of this in the within the same scope? According to Article 35, there is this principle, but the higher the number of cases and petitions, the lower the legal aid per person is, and so lawyers do this pro bono. So the European Court of Human Rights is not any ordinary court. Perhaps not everyone should go to the court. This requires another type of doctrine. Then we need to discuss the nature of the European Court of Courts. I met Reza Türmen by coincidence at the airport. So he thinks that what is the raison d'etat, the reason for the existence of the European Court? It's not a constitutional court. They wanted to transform it to this, but they haven't. It's not an international court of law as the international tribunal. There are different phases of the court, and it varies according to the different periods. But we can all really concur on the following. This is a court of human rights, and a human rights court needs to, this is what we expect, to really watch out for the rights of disadvantaged groups. This is my presentation. Thank you for your patience. Thank you very much. The first speaker was not able to connect, so now there is a connection, no problem. And let me introduce him very briefly.
Evet, Profesör Dr. Grain McKeever, Ulster Üniversitesi'nden. Başlığı davacılar için avukatsız adalete erişim. Kendisi hukuk ve sosyal adalet profesörü ve Ulster Üniversitesi Hukuk Kliniği'nin eş direktörü.
He is the co-director of the Legal Institute, and he focuses on participation in law court processes and the legal decision-making processes, and especially the results of access to justice are her areas of interest. Grain has been awarded over £1 million in grant income from the British Academy, the Nuffield Foundation and other funders, predominantly for empirical research on access to justice. She is the joint editor for the Journal of Social Security Law, a member of the UK Social Security Advisory Committee, and a member of the UK Administrative Justice Institute. Grain is also a former chair and executive director of Law Centre. The floor is yours, ma'am.
Good morning, everyone, and my apologies for the delay in joining you. I'm really sorry to have missed the start of the presentations, but delighted to be here virtually to share with you some of the learning that we have done that we've gained through our research in the UK. So I start from the premise that an ability to participate in legal proceedings is a basic facet of access to justice. It's a fundamental element of the right under Article 6 of the European Convention on Human Rights to be able to participate effectively as the means of accessing the right to a fair trial. And research on how litigants without lawyers are able to access this right identifies the barriers to participation that such litigants may face, at least in relation to civil and family court proceedings, where state-funded access to lawyers is more restricted than in criminal law proceedings. So I'm going to speak today about a 2-year study that we conducted at Ulster University of how litigants in person experience the process of litigating without a lawyer. And our research established that there are 4 main barriers to effective participation. First, intellectual. So this relates to a lack of understanding of the legal process, a lack of understanding of how the dispute resolution process works, what is required, how to progress the disputes, what information decision makers will require, and as well as that, understanding the decisions that are made and awareness of the legal issue under dispute. The second barrier is a practical one, and that's about being able to access specialist help or legal support and not knowing where else to get help and advice, or not being able to secure independent evidence to support your case. So information on the legal process can be very poor quality and very hard to find, and that means that litigants in person end up using information from different unreliable sources, and that can be problematic. The third barrier is quite personal. It's an emotional barrier, and it's when the process itself can cause anger, frustration, fear, and all of those negative emotions. We know that emotional barriers arise because there is a critical issue at stake, but the dispute resolution process itself generates significant negative emotions. We know that support can alleviate anxieties and instill confidence, and so the emotional barrier is important to consider. The final barrier relates specifically to those who go to court without a lawyer, and it's an attitudinal barrier. It's where court actors, by which we mean judges, solicitors, lawyers, advocates, court staff, often adopt a negative attitude towards litigants in person and assume that they will be difficult to deal with. Similarly, we see that litigants in person often adopt a negative attitude towards court actors, and then each see the system as one that's been held back by the demands to accommodate the other. And so this negative attitudinal cycle often continues. So the question for our research was what could be done to overcome these barriers? And three options tend to be presented in legal thinking. Get them lawyers, make them lawyers, change the system. So we put those options to participants in our research who were lawyers, court staff, judges, litigants in person, and those who supported them. The get them lawyers argument is to ensure that litigants in person have adequate access to a lawyer. And this is seen as the ideal solution, mainly by lawyers and by judges. But the challenges involved in this option, as our last presentation made clear, include the cost of providing lawyers for everyone and the fact that there is in the UK at least a right to self-representation, which many litigants in person choose to exercise. The second option, make them lawyers, is about providing reliable and easily accessible information on the law and procedures. But this is not generally seen as feasible because the knowledge and education barriers are high, and it's unreasonable to expect that all litigants in person can overcome them. So that leaves us with a third option, to change the system. The resistance to this option is generally framed as a cost issue. It would be too expensive to create an entirely new system. But it's not cost neutral to do nothing. Changing the system is also seen as problematic because of the traditional lack of system agility and the need for cultural and behavioural change that can be very difficult to achieve. So there is a need to recognise that there is no perfect solution. And what we need to identify are a variety of different ways in which litigants in person can be helped so that their Article 6 rights are protected, even if those barriers cannot be removed entirely. Realistically, we cannot provide all litigants with lawyers, but some will need them, and we should push for that where it is clearly necessary for access to justice and to protect the right to a fair trial and the rule of law. Equally, we cannot make lawyers out of litigants, but we can provide some support to help litigants navigate the system. And the focus here, therefore, is on reducing the practical and emotional barriers to participation, which we know can have a positive consequential impact on intellectual and attitudinal barriers. So our research that I want to speak very briefly about trialled a free procedural advice clinic that advised litigants in person on the procedural aspects of their case to see how it impacted on their ability to participate in subsequent court hearings. The clinic was designed specifically by the Northern Ireland Human Rights Commission as part of our research, examining how litigants in person participate in civil and family court hearings in Northern Ireland. So from the outset, the distinction between legal and procedural advice was critical. Procedural advice was focused on informing a client's decision by providing neutral information, which was framed passively in the more neutral language of relevant legislation, rather than set out as pros and cons of different legal positions. So this is very different from legal advice, which is defined as merits-based strategic advice that is capable of actively influencing a client's decision. The objective of the procedural advice offered was to get the litigants in person to think through their options so that they could decide for themselves what they felt their best approach to the problem would be. Now, there is a very fine line between procedural and legal advice, and so constant vigilance was required to avoid overstepping that line. And the litmus test was whether the advice would influence a litigant in person's decision, as legal advice would be expected to do, or whether it would inform their decision, as procedural advice could do. So we saw from the results of the research that the experiences of going to the clinic were overwhelmingly positive for the majority of the litigants in person. but there were a number of limitations identified in terms of the impact that have important implications for any proposed reforms and for agencies involved in advice and legal assistance more generally. The main limitations of the support provided by the clinic might be categorised as either too little or too late. So too little encompasses the views that support provided was too limited or it was not of the right type. And too late refers to the situation in which many litigants in person felt that they would have benefited from advice far earlier in the course of their dispute, rather than when they were already in court. So our findings were clear that the litigants in person were incredibly grateful for the emotional support that the clinic provided. The impact of that was to give them confidence and to humanise the process. And the value of being listened to, being heard, is part of humanising the litigation process for litigants in person. But it also underlines a contradiction that litigants in person struggle to resolve. To be able to be human in a system that requires you to distance yourself from the human emotions that you might experience. And there is an argument that this contradiction means that only lawyers will be able to take on this task of emotion-free advocacy. It seems unlikely that emotional barriers for litigants in person can ever be fully removed. But the reality is that the barriers need only be reduced in a way that enables the litigant in person to participate effectively in their hearing so that they can access their Article 6 rights. The clinic was regarded by litigants in person as helpful in breaking down some of the intellectual barriers to assist with preparing for the hearing, such as understanding that there was a checklist of requirements used by the court to determine the best interests of the child, a checklist that was laid out in legislation. Having this knowledge, however, of the legal test did not always translate into the litigant in person being able to apply this intellectual knowledge in the court. And even where judges attempted to assist litigants in person by giving them time and space within the hearing, checking for understanding and agreement, the participative gap could remain too great to bridge. Emotional support and on-task preparation were clearly important, but the fluid nature of court proceedings, where delays or new developments pushed hearings off course, could upend the preparation and recreate the barriers that had been tackled. The participants recognised that procedure only comes in the moment, and so that required an ability to make an immediate judgment on what they could ask or challenge that was beyond what the clinic could prepare them for and was often beyond their levels of knowledge and confidence. So ultimately, while the clinic was seen as helpful by most participants, it was not enough to overcome all of the intellectual, practical, and emotional barriers, each of which, singly or combined, were framed by a further set of barriers specific to litigants in person, namely attitudinal or cultural barriers that would return to the overall problem that litigants in person were seen as aliens within the system who should not be there. Now, the lesson that we learn from this is that it's not about rejecting the model of procedural advice or indeed other variants of this, but to recognise that there are limitations to what can be done to equip litigants in person to manage in the current court system. The strengths of the clinic were to increase the legal and procedural knowledge that litigants in person had, to provide them with an accessible form of support, and that could help to manage their anxieties over self-representation in particular, but more generally in terms of feeling supported and worthy of care and legitimate users of the court system. There are significant improvements, therefore, that we observed from the clinic in a system that otherwise left litigants in person confused, adrift, anxious, and alienated. But it seems clear that in addition to support being provided, change to the system is still needed. And to reiterate the calls of the last speaker, this is no longer just a system issue. This is a procedural necessity for access to justice and the rule of law. Thank you very much.
Biz de çok teşekkür ediyoruz. Şimdi soru cevap kısmında biraz vaktimiz kaldı. 12.30'u aldık çünkü mecburen geç başladığımız için en azından bu süreçte sorularınız varsa almak isteriz. Buyurun. Mikrofon hazır mıdır acaba? Mikrofonla imtihanımız.
If we can have a microphone. So please tell us to whom you are asking your question. My name is Sinan Yıldırım. I am the president of an association in Ankara. I am very happy to have met İdil, and I have a technical question about Porges. And normally individuals can listen. However, what type of a solution do you provide for hearing impaired individuals? As we use sign language, we cannot listen to these. The second question, in the courthouse, from the beginning of the process, I believe that this is still ongoing, and that is available for the last 3.5 years. So there are hearing impaired individuals who are vulnerable to 60%, and the system continues without any change for the last 3.5 years. And we want the legal control prerequisite to be eliminated. And we ask this question to the people who work at the courthouse, and there are many complaints about this. In July 2019, there was an individual who tried to trick 13 individuals, and that individual was released after a year, and no solution was brought forward for the victims, and only the witnesses are heard, and the court is not impartial in that regard, and no development has taken place so far. And in the large courthouses in Turkey for issues like domestic violence and divorce, we cannot have any technical support for communication. How can this be provided? And there are counseling offices. If they could at least have one sign language interpreter, they could help us to get information. This would make things much easier for us. And you talked about a call center which had visual aids, because for the group of hearing impaired individuals, there are significant problems in learning legal terminology. They do not know how and where to learn these. And in psychological problems and domestic violence, they have fears. And if they have the opportunity to see somebody visually as well, that would be helpful, and maybe a psychological support hotline can be established, but that provides visual support at the same time. And yes, for normal individuals, the sound can be sufficient. However, for people who have hearing impairments, we need to have some visual aids as well. We shouldn't feel ourselves excluded. Hello, my name is Abdülmecit. I'm coming from Diyarbakır. I am the president of a federation. I will have 3 questions. 2 of them will be to İdil. Concerning the podcasts, my first question is, so you talked about free of charge software. Can you give us any details, or would it be an advertisement if you do so? And I would like to check whether these are accessible or not. And the second one, what should be the length of a regular podcast? How many minutes? And third question, and a while ago, a colleague talked about her PhD thesis and talked about the legal fees, and she said applications could be made in 2 languages, English and French, I guess. Would it be possible to make the applications in any other language? Thank you.
Şurada beyefendi.
Güzel bir konuşmacı.
Çok teşekkür ederim. Öncelikle çok
Thank you. I benefit from it immensely. My name is Yaşar Bilge. In order to understand the question well, let's imagine a group of 10, and one person is disadvantaged, and the others are very much close to each other. In such a court, they really defend their own rights rather than defending the whole group. They isolate this one person. In order for this person, what kind of strategy, in order to change this situation, what kind of strategy should this person adopt in order to win over one more person? Thank you. My question goes to Stefanie and İdil. How do we differentiate this mass of information from the rest of the mass of information on the internet? This is very interesting, but when we talk of the internet, we have, a great mass of information. How to differentiate it? And secondly, the legal information transmitted here may violate something else. Perhaps the person may misunderstand this and may make mistakes. How do we solve the problem of responsibility in this situation, in such a situation? Hello. My question goes both to Professor İdil and Professor Çiğdem and Kasım Akbaş also talked about this podcast. Well, legal podcasts are things that I'm listening to lately. I realize that legal podcasts are really, these days, trying to make it a kind of, easygoing and nice to listen to kind of style in order to cope with the boredom that law creates. Have you done this? Is this what you're trying for? Hello. Our association is now trying to find a solution to the question, to a question. I am at the level when the domestic remedies have been exhausted. This is an individual case, but the consequences really will contribute to Turkey at large. We now have a problem. We have to translate the communication, and this is very expensive. One page, 500 Turkish lira, roughly $25. We cannot meet this kind of expense. People, the applicant's family is really a poor family, and there are no lawyers, but there are only lawyers who will help if you pay them. So I am face to face with a kind of dead end. So I would like even to talk to Ezgi Hanım on a one-to-one basis. What can we do in such a situation? Yes, we will try to use the possibilities of international law, but even our association does not have the financial capacity to meet this. Yıldız Albayrak is my name, and we are the association Life Without Barriers, Antalya. Hello, Ahmet Mert Duygun. I have a question for Ezgi. Thank you for all the presentations. Perhaps I had talked about something, perhaps you may have missed it. I'm curious, with respect to the European Court of Human Rights. In general, uses its right of discretion with respect to the to trials respecting fair trial. With respect to legal aid, does it take into consideration the specific concrete situation of the country in question? And then when you went into the question of budgets, I spoke about this a bit yesterday. These recent years, one of the things that is criticized mostly in regard to the court, the court is now, in a certain sense, bowing before Russia, Turkey, etc., those countries who have violated human rights very often. Because you work there, perhaps is there a kind of reform in the court and inclination for that in this context? Hello, everyone. Thank you for the participation and for inviting me. My question is, within the state, with respect to the bar associations and lawyers, there is a sphere of application or submission. If we didn't have sign language interpreters, they could have been used for the community of the deaf with respect to communication with lawyers. This sphere in the East State is what we were told was shut down. Then we asked again, so in the same submission, so, no, she's correcting herself. The same submission was required to be made over and over again. So how can we correct this situation? What is the situation of that sphere on the internet nowadays? That is to say, on the East State, the deaf are very, very much victimized by the situation because there are no interpreters here. Can we, can an interpreter be situated there, a sign language interpreter? My name is Ahmet. Yes, another question. You have to go, Yıldız Hanım, to the Human Rights Center of the Antalya Bar Association. I don't know why you didn't even think about it. We cannot hear Yıldız Albayrak because she's speaking without a microphone, so we cannot translate the answer. We can help you, says the person who has the microphone. With respect to the question Ezgi has posed, the question, in order to remind you, was the following. What does the European Court of Human Rights do? Because there are very practical consequences of this answer to this question. For long years, since 1998, as a lawyer who has been representing different applicants at the court and having witnessed the performance of the court, let me say the following. First of all, the European Court of Human Rights wants to shoulder a role as a constitutional court and spends great effort to realize this. It wants to be the watchdog of the European system of law. This is what it is seeking. But the essence of the situation does not permit this because it is a court of submissions. Other human rights organizations have more complex structures, not the European Court of Human Rights. It is a simple a pure judicial organ, a full-time organ that is based on a classical court organization form. It has to really abandon the idea. Of course, there are great problems here. There are the question of clone cases is really hurting the court. But then they have also made this an excuse because submission processes and the submission forms being monitored so closely, this really damages the prestige of the court and leaves many cases of violation without any decisions on the part of the court. Because here there are many grave violations of human rights. This is a comment. This is what I wanted to say. Someone in the back. Hello. Thank you for your presentations. My name is Alper. I have a question for Stefanie. You talked about certain examples of legal aid, and up until recently, we as an association, we always tried to imagine the following. Well, starting with children, we would perhaps receive submissions. How can you explain yourself better? What kind of instruments can we use? We looked for a mechanism of application that we could develop for with children. I wish this could have been done by the Bar Association because they have more, of course, knowledge on the questions of law. But in certain bar associations, you don't even have centers for the rights of the child. So in other words, within the legal system, the technologies, I wondered whether the technologies were of a kind that could be used by the child. Well, perhaps Professor Idil can help us in this manner. And I was also curious to know if this question, this process could be used by people in prison. Many people are in prison and they are really in a bind with respect to access to lawyers. And a kind of isolation is really difficult. And because phone calls and letters are paid for, this makes it even more difficult. So is this system used in other countries? Well, there are no other questions, it seems. How should we do? Shall we go by the same order? Shall we start here? Thank you very much, because the best side of this kind of meeting is that it makes you see things that you haven't thought of. We never thought of the question of how to reach out to those hard of hearing if you're preparing a podcast. Well, there's a great solution for this, because you can put the text of the podcast next to the podcast on the internet, on your website. Because the podcast does have a website, so you can put it in the website. Well, of course, I don't know the technology, so I may have misformulated it, but thank you. Thank you for drawing our attention to this question. This should be done. Wow, how did we not think of it? This is really a shame. This kind of technology has advanced so much. For instance, there's the blog pass. Robots read the text. I do my podcast in English, then I had it translated into Turkish so that people in Turkey could listen to it, but because I could not find anyone to read it, I discovered this program. It's a robot, one man, one woman. You give each of them their text and they read it. Technology, as you said. Well, this is even possible. It is even possible to put the text within the podcast. You can only learn about it once you inquire. Then the question was asked, what is the name of the program, the editing program? Audacity is the name. Well, of course, legal education need not be boring, but for this, it has to be participatory. If the teacher goes on the podium and, talks and talks and talks, then of course it's boring. There is no entertainment there. I said this in the presentation. You only have your voice. You cannot even say, sit down and keep quiet. Well, that's bad as it is, but in that environment, you can't even that. You have to make your voice a bit more fun. And when you're talking about restorative justice, for instance, or human rights violations, you can't laugh. You cannot say that I can't do this. But nonetheless, well, we cannot say that, we should have masochistic feelings because we're talking about violations of human rights. Well, as someone who's in the podcast business, let me say the following. To create content and to marketing it is very difficult. We have to work on it. But I see from the interest that has arisen here, we can learn from each other and do it better. I did this, in tears and, worrying all the time what to do, etc. Perhaps we can share with each other legal podcasts. What do they serve, what they don't serve, and what can we do to make them serve better? Let me finally say, with respect to Kasım Bey's question, between legal information and legal consultation are different things. We need legal information, to spread information among the people. We have to roll our sleeves and do our best. But legal consultation is different. What is legal information? Well, the period of appeal is 10 days, you know. This is information. But I suggest that you open such a case, or let us perhaps do this together. I propose to you that we do this is consultation. There is no reason why I should tell you, lawyers, what consultation is in legal terms. So, doing a legal podcast, you have to be conscious of this distinction. One of the announcements that I made you listen to, we say, we suggest that you go to a lawyer in order to receive consultation. If you don't have the money to go to a lawyer, then there is the possibility of legal aid, etc. So if this does not work, we're going to try something else. Thank you very much for your questions. I'm taking over. Oh, the time of the podcast. Super question. Very, very important question. It's not a matter of 40 minutes, 30 minutes. This is really a no-no situation. The time limit there is 15 or 18 minutes. There's an announcement and some introductory words. You can go up to 20 minutes. But the legal information podcast should not be long. You will see that everything that we did was below 10 minutes. One was 6 minutes. If you have a guest, it could be a bit longer. If you don't have a guest, then it needs to be lower than 10 minutes, shorter than 10 minutes. I took notes about the questions that were directed to me. With respect to the language of the court, you can send an application to the court in Turkish. After this has been communicated to Turkey, it needs to be translated into English or French. But in practice, as far as I can see, those people who work in the sphere of human rights know this better. In the registry, there are situations where you can continue in Turkish. The person is answering, but we cannot hear what he's saying. Yes, you can continue in Turkish. Yes, yes. So in practice, you can see this. Yes, there are instances where they continued in Turkish. The other question? Well, Hasan Kemal Bey will be contacting me on a certain question. Small NGOs really have a big problem in terms of legal costs. When we look at the decisions of the European Court of Human Rights, where we see, these international NGOs, very strong organizations. Well, they are permanent players in the field. Amnesty International, Greenpeace, ERAC. These are really, making submissions all the time. But small-scale NGOs are ignored. Their problems are ignored, and this is a big problem, and it's good that you raised the question. Matt had two questions. When the legal aid is given, is the specific situation of the country taken into consideration? Well, really, on the question of legal aid, the court is not that aware of what's happening. It's a registry, but because the jurist who does make the decision know these countries, they take this into consideration. And the bureaucratization of the court, everything really, being heaped one on top of each other, the exit of Russia, does this comfort the court? Well, of course, the number of cases will come down. But Matt's question also has to do with the following. Several years ago, Russia refused to pay its contribution to the court. It froze this. Later it continued or restarted to pay, but now it's gone out. What happens? It's not only this usual suspects, yes, Russia, Turkey, or Azerbaijan, who do not want to raise the budget of the court. Britain and Germany really also refrain from supporting the increase of the budget. They don't want to pay. Perhaps states don't want to contribute. Why should we always pay this court? That's all I would like to say. Bütün sorulara teşekkür ederim. Tabii ki.
So first of all, I'm not an expert on Turkey, but what I understand is that generally more cooperation is here needed, and also more training that association and also other organizations such as NGOs need to work more together, and because it was said that there's no technical support, for instance, for sign language. And I think it's what is also very important when you train lawyers or people working in legal aid advice centers, that they don't need to have an answer to every question of visitors of a legal aid advice center. This is not the point, but the point is that they should know where to turn to. If they can't answer a question, that they know, okay, I know an organization which might be better suited than me, and she or he could help you with the advice you need, because I also see that he has some capacity. There is actually some resources here, but there is no, as I understand it from your comments, no network, so that people learn to work together. And there was another question, I'm not sure if this was a translation issue. There was how to differentiate mass information. I'm not sure if this was meant about how to make aware of such technical tools, that they exist, IT tools. Oh, okay. Oh, this is okay. This is what I meant. So I worked 2 years ago. I worked with the Council of Europe in a project in Latvia where we established pilot legal advice centers and also created new online tools. And what we did, we created leaflets which we put at places where people visit, GP, supermarkets, banks, schools, where people actually go and chat and also then see a leaflet. Also, we advertised that those centers and new tools exist on social media, and it worked very well. Albert had a question, because my talk was rather about adults, how to approach children. Currently, I'm working in Laos with this UNDP with an NGO. I've just looked it up for it, but I could also show it to you later. It's called an NGO called Babsicle, and they, in particular, they work with children, and they have cartoons on YouTube where children learn what is right and wrong. Because in Laos, for instance, there's a huge problem with human trafficking, for instance, and how they can reach out to that NGO to get further help. So I hope I've answered your questions, and yeah, let me know if you have further questions or comments. Thank you.
There are some questions. Ben de birkaç soruya da tam cevap olmadı. Belki onlarla ilgili bir şey diyebilirim.
Perhaps I wanted to pose certain, repeat certain questions. Really, these were answered. E-state, we don't have any information on this. If we had certain information, we could make this into a strategic kind of submission. Shall we take this upon us as a duty? I don't know what it is about, but perhaps I will research into this question. I take it upon myself. Well, with respect to prisoners, convicts, that is to say, because the law of execution only arranges for interviews between lawyers and the arrested. The convict are totally shut out from legal liaison. From the point of view of the lawyer, from the point of view of lawyer rights, from the point of view of the prison system, this is a big problem. Perhaps something must be done on this. I would like to underline the special problem. The second question that wasn't answered. Well, direct submission by children. The ombudsman receives directly submissions and therefore perhaps you should use this possibility for children. For instance, there are certain recommendations with respect to certain kinds of cases to be opened up by children's submission, so you could perhaps you could use that route. Well, we really had a good experience in this session. Let me underline that. There was the commitment of solidarity between NGO and the Bar Association, so that's a very good precedent. Can we connect to our speaker online so that she can answer? Professor, can we listen to you?
I mean, it's been a really interesting set of questions and answers, and I think I've kind of got a few comments just that would cover quite a lot of it. So I'm going to answer the questions in that way, if that's okay. In relation to the comment on what does the European Court of Human Rights do, it is a court of submission, and in our research we established, looking at the legal doctrine around Article 6, that there is no right to a lawyer. The European Court of Human Rights does not recognise that individuals have a right to a lawyer unless their case is so complex that they are unable to proceed in a fair way. But even at that point, the court does not stipulate that a lawyer must be appointed. The protection of the right to a fair trial is what's at stake. So states can take a variety of methods and approaches to ensure that this right is protected for all litigants. And that brings me to the issue that's been raised about design that exists to assist litigants to understand and access their legal rights that is exclusive of the needs of particular communities. And we've heard this morning about those who are hearing impaired or who have no hearing. The solution to that is an idealistic one, but nonetheless one that can be embedded into a realistic approach at reform. And it's about inclusive design. So the research that we are working on at the moment is about designing a set of supports for litigants in person based on a model of design called human-centered design. And that's very often used to develop apps for your phone, for example. Technology companies will regularly bring in lots of different people and get them to problem shoot the issues that are coming up with this design they have created to allow you to access internet banking or to understand what the local council is doing. And so we are still in the process of evaluating that, but that we brought together lots of different stakeholders, including court actors and court users and members of communities who are underrepresented in court service design. And we designed something that would work for all of those users. And then, so what we have is, it seems very elemental, but it has been, our evaluations to date show that it's been very useful. It is a website, but there is also a Pathfinder tool, a web-based tool that's there that allows people to put in questions and to navigate towards an aspect of legal information that they need, rather than go into a website and look, and trying to find information there, because there's a huge amount of information. And I think bringing back that question about what we're providing is information, not consultation, I think that's a really critical issue. And so that relates to two things. First of all, that we are providing information that can be trusted. And one of the ways that we make sure that information can be trusted, and that goes to that point about how do you differentiate information that's available on the internet, you've got to be able to reassure people that the information is from a trusted source. And so what we have been able to do is to get our Department of Justice to sponsor this website and this information. And so people can be directed to that information through the trusted source of the state body, trusted in the sense that we know that the information is accurate. And so the state, the court service and the Department of Justice can funnel people to this information. So they're not just looking for it and coming across it randomly online. The other part of that I would stress, though, on this distinction between information and consultation is that recognizing there needs to be a recognition of the limits of this. So providing people with legal information, while very necessary, does not mean that they become legally competent and legally capable. And so we need courts and judges and lawyers to understand that this is a support system, but it is not a replacement for good legal advice or for judges being able to assist litigants to exercise their rights in court. And so I think that's critical in all of these tools that we are looking at this morning. None of them can transform a litigant who is not a lawyer into a lawyer. None of them can make lawyers out of litigants, and we ought not to make the assumption that providing people with information is going to make them legally capable and able to apply that information. What we can test is the extent to which it reduces some of those barriers to participation, like being able to have emotional support and practical support, and how that can impact on their ability to participate such that they realise their rights to a fair trial. Thank you.
Thank you very much. O halde zannediyorum herkes de acıktı. Saat 2'de başlayacak diğer.
Very much. So it seems we are now through with this session. Let's meet at 2 o'clock. Let me make an announcement. Please be here at 2 o'clock. We should start at 2 o'clock at the latest, because otherwise there are people who have to leave early. For those who are going to check out today, please do it now. For those who have not apposed their signature next to their name, please do so. We need that.
Hi. Çıkmışlar.
Ses nasıl? Güzel.
Yani.
Kapatalım.
Ses deneme 1-2 bu kez geldi galiba. İyi mi? Tamam, sağ olun.
Hey hey hey hey.
Ben de onu dedim. Şu konsantre olamıyorum.
Şöyle. Evet. Biz izninizle başlayalım. 10-12 geçiyor. Dışarısı da yavaş yavaş gelir diye düşünüyoruz.
Let us start. It's already 12 past. So we are here, 4 men sitting, and we would like to apologize for this before we start. Because of a technical change in the program, we had to do it like this. When the program was first organized, our colleague Aynur was with us, but because of a change, we had to be here like this. And when we have a look at the previous session, though, there was a balance, I believe, as all the panelists were women. So normally, Association for Monitoring Equal Rights does not organize meetings like this, and I try not to participate in meetings where all the panelist speakers are men. I would like to apologize for this inconvenience once again. As we are coming towards the second day, I believe we got used to each other, and we are so we have 4 speakers in this session. 1 speaker will be joining us online from the Netherlands. There are 2 representatives from bar associations and 2 representatives from civil society. And the speakers will have 15 to 20 minutes to present, and I'll try to respect the time because of all the delays that have taken place so far. At the end, I believe we will have the opportunity to discuss together. And we will follow the order in the session. I will first give the floor to Nahit Eren. He is the president of the Diyarbakır Bar Association. He graduated from Istanbul University's School of Law, and he works as a freelance lawyer in Diyarbakır since 2001. And during the time of Tahir Elçi, he was a member of the board, and he is the president, and in the last elections he continues to have the same position. The floor is yours. Thank you very much. Hello everyone. I would like to greet you all on behalf of the Diyarbakır Bar Association. Yes, in fact, the program, the conference started yesterday, but I could not be with you because of a commitment. I had to go to Barton, and I met with certain members of certain bar associations. Because of the mine explosion in Barton, we wanted to go there to extend our condolences to the families who have experienced losses. I was in Barton yesterday, and after we made our visits, there were a couple of examples concerning access to justice. We were there, we went to the prosecutor's office, we visited the families, we met with a couple of civil society representatives, and Barton Bar Association offered us dinner, and as we were eating, there was a ban that was announced. Starting midnight yesterday, there was a ban about not entering Barton, Amasra province for 3 days. And people started to look at me, and Sibel, the deputy president of the Union of Bar Associations of Turkey, was also with me. And in Diyarbakır, we would experience activity bans, event bans, but we have never experienced that entry to the town would be banned. And so I am sure that this decision was taken as the Bar Association presidents were there yesterday. And we will start to come here more, a colleague said, in a visit to a family. We really had hard time remaining calm. It is a very sad event. and the sister of a person who lost his life works at the Social Security Agency. And she said that my brother wanted to retire, and as he was expecting to do so, I will need to help the family have a pension because of his death, and please be with us, please help us. This showed us the expectation from the bars in Turkey. I don't know if you could read it, but there was an announcement from the governor's office in Barton yesterday, and so there was a decision in line with the issues mentioned. Individuals who came to Barton for different activities have visited Amasra district, and their entry to the district is banned. So a governor's office in Turkey, the highest authority, takes this type of a decision. What does the decision tell us? It doesn't tell us anything. What will we be doing in this province? 41 individuals lost their lives, and it is a murder file. We cannot call it an accident. Bars shouldn't come there. Union shouldn't come there. This is actually showing us the approach to justice in Turkey. I could listen the presentations in the morning sessions, and I checked the program for yesterday, and I understand as if we are taking access to justice from different perspectives. So access to courts through a representative, through a lawyer, access to courts without any fee, paying fees. And so when you have access to the court, will justice be there? Whether it be through a lawyer or not, I will give you a couple of procedures from the Diyarbakır bar regarding the procedures, because in Turkey it is as if there is an established legal aid mechanism. I believe the situation is exaggerated. I don't think it is like that, and I will explain why that is not the case. I will first elaborate on the technical dimension, and then I will talk about the process after one makes it to the court. According to the criminal proceedings law, we expect the individuals to be at least at 18 years of age, and there needs to be some legal aid. We have criteria. The individual has to prove that she is poor, and then we make these individuals get in touch with lawyers, and the lawyers can bring the files to the court. But then can justice take place when we do or complete all these steps? Something that is not discussed in Turkey is that there are people who ask for justice from the perspective of identity, others from the perspective of religion. These people have access to the courts, however, there are obstacles in front of them. The state has certain codes that are in place that doesn't allow them to have any results. Without discussing Roboski, or without discussing Tahir Elçi, or without discussing other murders whose perpetrators could not be identified, we cannot discuss access to courts individually or through lawyers. If we do not cover all the other aspects, the jigsaw puzzle would not be complete. As the president of a bar association, I am currently in the judicial system in Turkey, and what type of services do we provide in terms of access to justice, and what are the roles of bar associations? You might have followed this, and I believe there are lawyers amongst us, and we lawyers are at the point of complaining, and in fact, in the justice system, there is the right to defense, and we want to provide those services. And there is a respect to representation in access to justice. However, this area became a problematic area, and in line with the right to defense, we are trying to follow up all the files, all the cases, and you know that many bar associations do this. However, on the other hand, we have to protect our profession as well, because the Constitution bans certain things, and the Bar Association continues its talks in an attempt to improve the situation. Imagine that in the profession of attorneyship, the fees are very low for the services that are delivered. As when it comes to legal aid, I do not know to what extent things were covered. However, you should know that this is a very badly established system. It is not based on the population of a province, or it is not based on the number of files that are covered at that location. And for the legal aid that is to be provided, there is a certain budget that is allocated. Imagine it is 100 million lira. So how do we allocate to respective bar associations? Is it about the number of cases they have, or is it allocated based on the number of applications by individuals? I believe it is based on the number of lawyers in that location. There is a fixed allocation that is sent. So it is in 4 installments. For Diyarbakir Bar Association, it was, I believe, 2,175 liras. This has to be paid to the lawyers on a case basis, and then you will have expenses like for the staff, for the rent, or for certain registrations. In such a system, you are trying to carry out legal aid services. In the Diyarbakir bar, since the 13th of April 2021, there has been 2,900 applications, and we could only accept 1,050 of these. And I was asked about how delayed were the payments. And for a service that was delivered by a lawyer a year and a half ago, we have not yet made the payment. What is striking is that in Diyarbakir, of the 2,900 applications, nearly all are by women. These are divorce cases, alimony cases, and guardianship cases, custody cases, which means for disadvantaged groups, we are trying to do certain screening and then accept the cases, and we try to prioritize such files. And there are other cases as well, but we have to prioritize divorce, alimony, and custody. So with this budget that is available to us, we can have this type of a prioritization. So all the bars in Turkey have their payments with the same system, but some bars do not have any applications, and this money is in the budget and it is used for other purposes. And in Diyarbakir, there is a significant rights awareness, and maybe this type of a budget can be spent for raising the awareness of individuals in Diyarbakir, because there are strong civil society organizations. The individuals are aware of their rights. But in Central Anatolia, for example, I know certain bar associations, and I know that budget for legal aid is even higher. However, it is not spent for the purposes it should be spent. And in the meetings at Union of Bar Associations of Turkey, we made a suggestion and we said that let's identify the budget based on the applications at a certain location. And the president of the bar is given an authority. However, we experience difficulties when we try to make evaluations. The system foresees certain criteria. For example, if the individual has a house in the Sur district of Diyarbakir, for example, you have a house, and if you were to sell it, you wouldn't be able to do so. However, there is an evaluation about your being right, and then there's an evaluation about your poverty. And if the individuals comes to a legal organization, we present this person with documents. Even if the individual had a minimum wage, you wouldn't be able to assign a lawyer free of charge. If the individual has some disability payment, or if a pension, because of these, you wouldn't be able to provide legal aid. I do not know what type of a position or what type of a stance the bars can have, but this is a significant problem. In Diyarbakir, for example, despite all these problems, we have an established system. For example, we have registered lawyers at the Women's Center, and those lawyers are trained to begin with, and in order to accept a legal aid application, they have to go through a training, and then they have legal aid shifts, and they are paid daily legal aid fees. Why do we pay this? Because the law creates problems in by not providing us any fees for this service. For example, preventive protection requests under 6284, for example, as we cannot convert these into lawsuits, we cannot provide any payments, and the lawyers who cover the shift are there. However, there are significant shortcomings, and people cannot get paid for the service they provide. Yes, in Turkey, as I said as I started my presentation, the main topic is justice. I read the decision by the governor's office in Bartın. I will now read an announcement by the Ministry of Justice. Every 3 years, we have a strategic plan package or an action plan. I think this was published back in 2019. I am about to finish. Let me read this. I guess it was 20 minutes, my time. So the strategy document has a mission. Supremacy of law, independence of judiciary, and human rights are taken into consideration in the effective and fast delivery of legal services, and the policies should be developed to this end. I wish those could be done, and I wish we didn't have anything else to do. We have concepts in place, yet we do not have anything concrete in practice. I can easily say this as the president of a bar in Turkey. In Turkey, there are systematic problems when it comes to individual access to the justice system. However, there are inequalities in the judicial practices. That is our main problem. For example, Diyarbakir Bar is pro bono, and we have been following up certain cases for years. And Union of Bar Associations of Turkey, we know it through them that there are individuals in search for justice, and regarding this request, there might be civil disobedience, and the support from the side of the bars is very important. And after the president of the Union of Bar Associations, Yaşar family visit, and we know how people were arrested. And for Roboski, again, Union of Bar Associations coming, and we have witnessed the results. There is expectation of justice for some cases. If we cannot provide justice to such cases, we cannot solve the problems about access to justice. I would like to provide some more examples. Remember that Tahir Elçi case is there, and judiciary wants to be fast and effective. If it wants to be so, it can do it. Because of the statements provided by Tahir Elçi, we see how fast cases could be opened, and despite the fact that 4.5 years have passed since his death, it is quite recent that the lawsuits are filed. So this is an area where us jurists have to be more active. Yet, if the perspective about the judiciary doesn't change, and if impartiality is not there, it will be only us sharing our views in this hall, and we would not be changing the mindset. As the Diyarbakır Bar, we know our responsibility. We are ready to be there. We have been investigated, we have been interrogated, we have been arrested, but we did not lose our courage. We are trying to do our best. Thank you very much for listening.
Çok teşekkür ederiz. Hiç ara vermeden hızlıca diğer konuşmacımıza geçelim. Online katılacak.
Next speaker will be speaking online. Is the connection ready? Jelle Klaas from the Netherlands will be participating in our meeting. In the last 20 years, he has been a human rights lawyer who has been litigating cases against discrimination and poverty. And we worked together, we talked with him. In 2014, he started PILP together with human rights NGO NJCM to explore strategic litigation in the Dutch context. Since then, PILP has launched big cases against arms trade, racism, and for the right to protest, the right to water, and a lot of other topics.
Hello.
Hello. Yes, thank you so much for having me.
Yeah, the floor is yours.
Thank you so much. It's an honor to be speaking to this conference, and I'm very aware that what I will be addressing will be quite different than the other topics and the other spheres that I've been hearing about. But still, because it's about access to justice, with our project, we have tried to find different ways for movements, communities, activists in the Netherlands to get better access to justice. And we thought, well, it might be interesting for you to hear about that. So quickly about myself, like it was already said, I'm a human rights lawyer for the past 20 years in the Netherlands, specialized in social, economic, human rights, so helping homeless people, people that get discriminated and stuff like that, mostly on legal aid. So a lot to be said about the legal aid system in the Netherlands. From the previous speaker, I completely understand that the system in the Netherlands is much better, but it's also under pressure and getting more and more difficult for poor people to get access to an individual lawyer. But with PILP, what we did in 2014 is try to shift from individual cases to look at strategic litigation and to explore what strategic litigation is in other countries and how we could maybe apply it in the Dutch context. So in my next 17 minutes, I will be telling you a little bit about how what we think strategic litigation is, how we work as an organization, as lawyers working for an NGO, and I will give you a few examples of the cases that we are doing. I think a very important disclaimer is that everything I will be telling you is from the Dutch context and from our own personal experience, and is absolutely not the only way of looking at this. So there are a lot of ways of looking at strategic litigation, at the use of law for activism, political cases. It's very limited to the Dutch context. So it's just a experience, it's not the way of looking at it. So with that disclaimer out of the way, like I said, in 2014, we received as a human rights organization that has been in existence for 40 years, the NJCM, doing lobby and seminars and organizing conferences like this. We received a small fund from an international foundation to start a project on strategic litigation. So that was in 2014. And I went to other countries, especially the Anglo-Saxon world, America, the United Kingdom, South Africa, to look at how other lawyers work with strategic litigation and with movements. And we try to get the best practices from them and try to apply them in the Dutch context. Well, that was 2014. Now, almost 8 years later, we are with a staff of 6 people. We have 3 in-house lawyers that also do cases. We do cases on, well, several topics that we already described. And I think also interesting for this conference, but I will get back to that in a minute. We work with almost all the big corporate law firms in the Netherlands, 17, with pro bono lawyers and with expert lawyers, social lawyers, human rights lawyers, etc. So let's first start a little bit on what we think strategic litigation is, then tell you a little bit on how we build these cases. So we think, again, this is our personal opinion and something that we, from our context, view it, is that strategic litigation is strategic on 2 levels. The first thing is that we view litigation through the lens of the movement. So if a movement or a community or a group of activists wants to change something like the access to the right to water for children, it's one of the cases that we are doing. Children can be cut off from water in the Netherlands if their parents have not paid the bills. And that's a big problem. Children without water suffer. If you want to fight that, you can choose for a lot of tools. As an NGO fighting for the right to water, you can lobby, you can get media attention, do civil disobedience, and one of these tools is litigation. So what we try to look at it is it's just one of the tools in your toolbox. It's not the highest, it's not the only one, it's not the most authority, with the thing with the most authority. It's just one of these tools, and we as lawyers should help the movement thinking on when is the best timing for that tool, in opposition also to the other tools. So the idea is that we want the movement to win, and if they can make more progress with protest or with a lobby report, they should do that. They shouldn't work with lawyers and litigation. They should only use litigation when it will benefit their cause, so the thing that they are fighting for. So I think that's an important difference between strategic litigators or movement lawyers, is that we are cause lawyers in opposition to normal lawyers, like I was for a lot of years, that are case lawyers, that look at a case-by-case basis. If a person comes to you and you have a good case, it can be a strategic case, it can be political, it can be everything, but the point of view that where you start is the individual's point of view. With cause lawyering, you look at the movement, at the broader community, and you take their viewpoint as starting point. So that's the first thing where the strategic looks at, on the using this instrument in opposition to all the other instruments that you can apply if you want to win on your cause. The second thing is that the strategic looks at the strategic use of the litigation itself. So within the litigation, you can push a lot of buttons. And that really depends on every context, of course, and differs very much per country. But for instance, in the Netherlands, I guess also in Turkey, you can choose to go to a criminal court, to an administrative court, to a private court. You can decide the timing. You can decide what kind of lawyers you want there, what your framing of the case is, what claimants would be the best, what claim you want. And well, you can think of 1,000 other small things that you can adjust to have the case have the best impact and contribute the most to the cause for the people that want to fight it. So I think if you have a perfect strategic litigation case, then it has two important aspects, two important elements. The first and absolutely most important thing is that it should be about the cause of the community you're working for. So if you are doing a case that has an interesting legal aspect that can change jurisprudence or convince judges, but it does not reflect the struggle of the people you're doing it for, it's not a good strategic litigation case. A good example of that is the DH and others versus Czech Republic case against the Czech Republic with the European Court in Strasbourg. A brilliant case on discrimination. Very important, we use it a lot, was for the Roma community against segregation in school, in education. A case that was won for children, but when they went back to the community years after that case, the Roma community felt that this case was not about what they wanted it to be about. They said school segregation, of course it's a problem, but we were facing police violence, evictions from our homes, and a lot of other issues that we would have liked human rights lawyers to help us with. And instead they went for a case with children that when we eventually won at the European Court, these children were by far adults. And it didn't really serve the emancipation of our struggles. So to make sure that the community, that the movement that the case is about them, it is very important to keep them in the driver's seat. So always talk to them, take them to the meetings, explain everything about the technical issues, but very, very important, listen to them, go to their protests, go to their meetings, to really be sure that you are serving their cause and not think about what your own moral ideas are about law, but take their points of view as a starting point. At the same time, the other element is that if you start a case, it has to fit the rules of the arena that you will go into. So if you make a case like a pamphlet, like a manifesto, no judge will listen to you. You can do that maybe once, but then after a second or a third time, again, I'm speaking about the Dutch context, but I think about a lot of other contexts. This is also true. You need to have an activist point of view, but at the same time, you need to be a good technical lawyer. So the case has to fit the rules of the system that you will enter. So an example of that is the Schiphol fire. There were 11 people killed in the prison in Schiphol, the airport in the Netherlands, in 2007. These were refugees in a detention center, and it was horrible. And the government did not do enough, at least according to a lot of activists and anti-racist and refugee activists. They said the government is responsible, and they're not taking the full responsibility. So there was a lot of political discussion and protests. And then one group of activists said, we want the minister responsible for refugee care. We want her to be criminally prosecuted because she's liable and she is responsible for what happened. So what they did is they went to the European Court in Strasbourg and they asked to the European Court, could you please decide that this minister, Verdonk, has to be criminally prosecuted for the 11 deaths. From a movement perspective and a perspective of righteousness and justice, this is fine. It's a good claim. But from a legal point of view, this isn't something you can ask the European Court. They cannot decide that a country has to prosecute criminally a minister. So they lost, of course, on admissibility. It was a single judge inadmissibility decision. But the Dutch media don't understand admissibility things and all these technical issues. The Dutch media said, European Court in Strasbourg says, minister did nothing wrong in Schiphol fire. So I think it's very important that if you use this tool, and I think I'm talking to a lot of lawyers here in the hall, so I know you will be very, I know you will understand what I'm meaning, but it's important for our clients to make this difference, that we support them on the political point, but at the same time, we really have to be, we are in control when it's purely about the technical part. So how do we build these cases? We build these cases by first listening to people and getting new cases from, we work for the trade unions, anti-discrimination groups, the Roma Sinti Travelers community, and and a lot of NGOs, when they come to us and they say we have a specific issue that we want to fight, then we first organize a brainstorm with all the people that are active on that field. Everyone in the community, the people that are affected, experts, academics, to decide, to hear in the broader aspect, does everyone see this as a problem? Is this the issue where it hurts? And could litigation help bring this issue, bring victory a bit closer on this cause? If, like the right to water for children, for example, everyone says it's stupid that in the Netherlands, a country where it always rains, you can cut off children from water because of poverty. This needs to be fought, and litigation could help to destroy this law. Then we do a second brainstorm or second research where we bring in universities, law clinics, and pro bono lawyers. We work with Pro Bono Connect, that's also an NGO. They are in connection with 17 of the biggest law firms in the Netherlands, and they supply legal aid, pro bono help. So they also go to these brainstorms, and together we try to build a strategy and build a litigation. I think it's important to stress that these pro bono corporate law firms, it's great that we can make use of them, but because of their political point of view, most of the time they're serving the interests of multinationals, but they have quite good lawyers, of course, good in a technical sense. We don't let them have the control of the case, but we do it together. So we build these cases in co-counsel. So most of the cases we have like 4 or 5 lawyers together on a case, where the pro bono lawyers do the more technical stuff and we do the more political, human rights related stuff. I think I have a few minutes left, so I'll go into a few of the examples. So one of the biggest cases that we're doing right now is against ethnic profiling. Ethnic profiling or racial profiling at the Dutch borders. Just to give a clear example, one of our clients is a professor and a politician, and he is a Dutch citizen, but he has a black skin. And every time he goes into the Netherlands, he is taken out of the row and the police questions him and checks whether or not he has a permit to stay. He made a complaint about that, and we found out that the reason he was taken out of the row was based on a risk profile, that they were looking for Nigerian money smugglers that fit the profile of man, walking fast, dressed in a suit, having a suitcase, and having a non-Dutch appearance. And in the complaint procedure, also the chair of the complaint commission said, yeah, Mr. Mapanzo Bamenga, that's the name of our client, you don't look like a Dutch person, so you fit the profile that day. And that case is about whether or not the border police can use ethnicity or race as one of the elements in selecting people at the border. We thought we were going to win. We had all the professors, all the academics. We do the case for Amnesty International, anti-racist and anti-discrimination bureaus, a few anti-racist activists, and a few black citizens. It's a collective case together. We thought we were going to win it because we have all the good arguments and yeah, it's very racist policy. But we lost horribly last year. That did give us a lot of attention for the cause and for the campaign. And now we are in appeal with the case. And on the 8th of December, we have the appeal hearing. So I think it is a good example. More people came to the streets. There was much more awareness of ethnic profiling, that also Dutch white judges can be quite racist or problematic on this issue. And it is a good example of one of our cases where we did get a lot of more attention for this cause, even though we lost in first instance. I really hope we are going to win in appeal. Just to hover over a few other examples of cases we're doing a lot of right to protest cases. So we're helping climate change activists, trade unions, others with what their rights to protest are. We connect them to criminal lawyers, not criminal lawyers, but you get the point. Lawyers that can help people that are in prison. And we give trainings on the right to protest. And we do a lot of court cases there. Like I said, the right to water, we have a big case against the water companies in the Netherlands and the state. We do that with a child's rights NGO, because I think to end on two practical issues, we can, in the Netherlands, there's a lot of, there's a good rule of law system up until a certain extent. We still have a lot of issues also with legal aid cutbacks, institutional racism. There are a lot of problems. At the same time, we can go to court. Sometimes we can even win, and we can go to court with NGOs. So it's relatively easy to file cases in the public interest. I think easier than in a lot of other countries where you can only go to court with individuals. Final thing, also because this is for this conference, we get funding by foundations, so family funds. So we are a foundation ourselves. We get some money, not a lot, but with that we can pay all the staff and also the court costs. So our clients don't need to pay for anything when they go to court.
Last minute, Jelle.
Yeah. I was indeed about to end. So this is so we try to make the bar, the access to justice for our clients as low as possible. So that's why we try to take away these court costs. And with that, this was my contribution. Looking forward to any questions later on.
Thank you very much, and stay with us, please, from there. Maybe you can hear some questions from the room. Thank you.
Yes, we continue. Hasan Kemal Elvan will be our next speaker. He has 30 years of practice in the field of law, and at least 25 years of that time he spent defending victims who had their fundamental rights and freedoms violated. He represented the applicants in many cases before the European Court of Human Rights and the Constitutional Court. He chaired the Human Rights Commission of the Istanbul Bar Association for a short time. Soon after establishing the Human Rights Center of the same bar, he served as a member of the Executive Board and General Secretary for 2 terms. Since 2012, he has been practicing as a lawyer registered with the Antalya Bar Association. We haven't met before, and I know him through the translations he makes. Of course, I have not updated the blog for a while. I even forgot about it. And I would like to greet everyone with respect, and everybody is tired, and I would like to ask for your patience, and I will try to talk about my personal experiences. First of all, we have to understand in what type of an environment the Human Rights Center try to operate under the bar associations, and what are the limitations we experience. I will try to talk about these, and what type of opportunities do these provide, and the presence of human rights centers within the bar associations, I mean. And my priority, in fact, will be to make a preliminary identification in order to be able to cover the topic comprehensively. If I start from a general perspective, it will be better. It might be boring, but I believe it is necessary. So, as the first thing, I will go back to the spirit of the time. And if we don't comprehend this change, it will be difficult and it will be leading us to wrong conclusions. The start of the human rights movement dates back many years. However, the architecture was established with the institutions that were founded after the Second World War. And until recently, international human rights law and all this fight had a meaning. But in today's world, democratic institutions are going through an erosion, and the architecture that I mentioned is being challenged. And such institutions, their contents are being removed, they're emptied, and there are significant crises when it comes to solving new problems. This is experienced at a global scale and also in countries like Turkey at a local level, and this has very grave results. So this erosion that I am talking about, there needs to be a combat zone that we need to identify. On the one hand, we have agencies coming from the past that are being that are not being able to respond to the needs of the time. However, the actors that might replace them have not appeared yet, and the crisis appears just at that junction, and I believe the process will be a painful one, and it seems if we live long enough, we will be experiencing this crisis together. And in Turkey, there is something else that the political movements sometimes bypass. In the coming future, we have to be face-to-face with the climate crisis. And there are problems that are created by this crisis. For example, in the recent months, the flood disaster in Pakistan had millions of individuals leaving their neighborhoods, and they became climate refugees, and there might be entries to Turkey. And disadvantaged groups are being gravely affected. It will strike elderly, it will strike women and children, and those will be especially disadvantaged. And under the chaos that has been created, those will be the people who have to work. So such crises are coming, and human rights movement needs to come up with relevant measures. Underlying this crisis, we have the transformation that is brought forward by the information technologies. When I started my profession in 1993, I was writing a typewriter to make the applications. We have covered computers and everything, and when it comes to access to information, there is an enormous ease at doing things. I can file a lawsuit before going to the courthouse. Everything got quite simplified, but amongst all these things, there is a phenomenon called social media. Social media, on one hand, makes things very easy for us. On the other hand, it erodes our basic rights and freedoms, and it poses a threat. And we are face to face with a crisis called post-truth, and we are questioning what truth is. And this is being experienced worldwide, and the societies are getting polarized in the slightest of issues, and people find it hard to come to a shared conclusion. And we are losing the public sphere. So for alternative dispute resolutions, we see this appearing. For mediation, we see efforts with ill fate, and sometimes the results of such cases might be completely against the needs of a worker, and the losses cannot be compensated for. In many areas, in many spheres, we see fragmentations at micro level, and all the institutions and our lives are also being fragmented. When it comes to access to justice, without understanding the process we are going through, it will not be realistic to have expectations from the access to justice. In Turkey, in the ecological atmosphere we are living at the current moment, in the society and in the judiciary profession, we cannot see a unity. Everybody needs human rights, but not for the common good. It is for individual needs, and this creates a polarization. And for bar associations and human rights centers, it is not possible to meet on a common ground. Human rights centers make the effort to create an awareness. I sometimes visit schools to elaborate on human rights to the youth, and I found a myth that I can talk about, and it is about Sisyphus, and I would like to talk about it for those that don't know about it. In the ancient Greek, the king of one of the cities is punished by the gods, and he has to carry a rock to a summit, and before he reaches the summit, that rock rolls down and he has to push it further. And this is in fact the tragedy of the humankind. And we have in fact lost these stories. Let me not get distracted. And through that anecdote, the children and the youngsters have something appearing in their minds. And in that regard, we have problems concerning the presence of human rights centers within the bars. And I have started in the Children's Rights Center under Istanbul Bar Association, and I became a part of the effort. And during my professional life, I realized how destructive a problem this became in time. When some administration is committed to developing human rights, there are effective efforts which results in the blooming of such centers. The establishment of the center was a similar effort, and I was a member of the executive board of the Human Rights Center itself. During those processes, there was an incredible momentum, but when the administration changes, the problem, if it doesn't coincide with the understanding of the current administration, all that experience goes to waste. And it takes years for that center to be revived. And recently, the Human Rights Center of the Ankara Bar Association shows us how a problem can have such destructive results. And it went up to the resigning of the president of the Bar Association. And without seeing the politics involved, it is very difficult for us to be present, and it is very difficult for us to be effective. And this seems problematic. Yet, Diyarbakır Bar Association, we might say that they are immune. There might be different understandings within the group. Despite those differences, they have the common denominator of human rights, and there is an incredible capacity there. And it is not possible to say the same for other bars, and this creates a handicap. There are already problems in the functioning of the judiciary, and there are delays in our intervening with the problems, because comprehending the judiciary problems can only be possible with the lawyers and through their systematic supervision of the system. And the courts have the right to say what the justice system is, and we have the same responsibility. And we are in an area of power, but we have problems in exercising our rights. And so I have a general perspective to things, because many specific things have been covered since yesterday. That's thanks to them, I feel myself more flexible and comfortable. That's why I try to come up with this type of a presentation. Surmounting these problems is difficult, because it's not easy to compensate for the losses. And to have a lawyer be trained in the field of human rights, it is long. It can take at least 4 to 5 years. One of the responsibilities we have is to train such individuals as human rights lawyers. This might have been covered in the morning by a colleague, but in the law schools in Turkey, there is no systematic education about human rights. There are around 80 law schools, and those that provide human rights curriculum is very limited. And and most of the lawyers who come to our center do not go through such a training before coming. And when it comes to monitoring and intervention activities, we have to train them. And detention centers are in need of such people, and those lawyers who come to the center cannot be appointed to those centers immediately. You have to be comprehending the awareness. And lastly, I might say that I am a person who has been the president of a human rights center for quite a long while. I believe this started back in 2014. It will be 10 years soon. And this is due to the very special position of the Antalya Bar Association, because none of the groups that are polarized in the politics have the opportunity to come to the power by themselves. This creates an advantage for us, and it makes it possible to build capacity. In that regard, we are very lucky, but this is a very fragile situation. It can easily be reversed, and we are aware of this. So we are trying to walk on this very fragile ground. I would like you to understand this. Thank you very much for listening. Thank you. And now it's our last speaker.
Ozan Devrim Yay, çevre mühendisi, hukukçu değil ama ben hep söylüyorum, hepimizden daha hukukçu olabilir. Eskişehir'de Yaşam Bellek Özgürlük Derneği'nde ve Eskişehir Okulu Derneği'nde faaliyetlerini yürütüyor. Eskişehir Okulu Derneği'nin de birlikte yönetiminde bulunduğumuz arkadaşlarımızdan.
Ozan Devrim Yay carries out his activities in Eskişehir Life Memory Freedom Association and Eskişehir School Solidarity and Research Association. He was working as a lecturer at Anadolu University Environmental Engineering Department until he was dismissed from public service with a statutory degree number 686. He participates in activities such as language courses, citizen journalism, monitoring and reporting of rights violations, trial monitoring and reporting as part of Life Memory Freedom Association's activities. He represents the association in the Human Rights Defenders Solidarity Network and Language Rights Monitoring Documentation and Reporting Network, of which the association is a component of which the association is a component. Well, let me try to speak loud. Thank you. I usually do not feel very tight when facing a crowd, but I'm face to face with very important experts. So the doctor there is, a PhD of environmental engineering. Our organization is a local organization. Of course, the distinction between national and local is not that important. We also really take up international questions as well. From my own point of view, I will be speaking on 4 different points with respect to the question of how NGOs can participate in the struggle for access to justice. From what Kıvılcım said today and Nahit Eren said today, we can think of the defense of access to justice as a kind of medicine, which is, public health like situation in law. That is to say, you go to a court without going to this police precinct. And then there are, of course, different processes that start. There are things that NGOs can do, and I'm going to be talking about them. with respect to the judicial processes, to report them, to intervene in them, and sometimes litigate ourselves in favor of rights. After the decision process, it's a question of whether decisions are or are not implemented. Perhaps we could make a monitoring activity in order to see to it that there is amelioration. And then the convicts in the prisons. This had come on agenda before, and civil society can do many things here as well. After this classification, let's go over to the first question. First of all, whether this is reflected in judicial organs or not, there can be interventions in daily practice on these questions. At the local level in Eskişehir, this is what we're trying to do, monitoring what's happening and to spread the results of the monitoring process. And of course, what is a right? How is this defined? And providing information to the public. Kasım said this. Well, citizen journalism is very important for us because you generate some knowledge and information and you want to share it. Especially the social media is very important. Most people are following this, and we went to several trainings for citizen journalism, and we are trying to do apply the results in the social media. Alongside reporting, writing reports, that is, we wish to address the people, the citizens, and therefore we write it in the form of news. Of course, these four titles interpenetrate, so a case that you're reporting about can go to court, for instance. For instance, there were workers who were laid off because of their trade unionization activities. We tried to help them out and we tried to support them. They had resistance, they had picketing established near the factory, and we went to visit them all the time. And you can always access these from our website. When we first established the association, it was the Association for Educational Rights, so we work in that field as well. There are workshops that we organize, and this memory work is very important for us. And sometimes we did other things. For instance, well, we were not successful, but without exhausting domestic remedies, we have tried to reach the European Court of Human Rights. Law enforcement in protests, taking pictures. That, of course, violates the rights of confidential and private life, but we received rejection from the European Court of Human Rights, but nonetheless, we thought that this was a good idea. We will try again, we will be defeated again, and then one day we will succeed. We also wanted the High Court of Cassation processes to be monitored. We have been monitoring cases for a long time now. Now there is a debate. Well, there is this debate on whether to notify the delegation of judges that there is an organization that is monitoring the case. well, if you do, of course, there is a pressure on them. But if you don't, then of course the judges may become much more strict and rigid with the defendants, and that gives you a lot of leeway to criticize. In general, NGOs can go to court and in order to be intervening party, but usually this is rejected. Sometimes this is admitted, and therefore these organizations monitor the case on behalf of civil society. Sometimes we meet structural problems, but although it is difficult, sometimes we try to iron out these structural problems by talking to the authorities. We started to use new instruments. We have filed cases in courts in Eskişehir. There were 2 bans in Eskişehir, and we went to court against both of them. One was the concerts, the prohibition of concerts, started in Eskişehir. Of course, the governor's office did not characterize it this way, but it was that. And then the LGBT activities were banned, and we have a case against that. The next month we are going to have a hearing on that, so we can go for litigation against some of these prohibitions and violations. In Istanbul, we were at a training program. Some applications we do on an individual basis. Sometimes we do it with the legal person, on behalf of the legal person. We discussed this in Istanbul. Either could be useful depending on the overall context. Because administrative justice is very slow, I took, for instance, a case to the European Court of Human Rights because of the delay in the whole process. But I did it myself, although this was on behalf of the association, really, depending on which one is more useful. Certain structural problems at the level of the High Court of Cassation have become the topic of our litigation as well. We had a report written, and self-criticism, perhaps valid for other NGOs. During the monitoring, we tried to bring out the discrimination, talking to both the defendants and the lawyers, but we never talked to the Roma because we realized that we were not at all in contact with any Roma person. Well, I'm going to be talking about the networks between organizations. These are very, very important. Well, this point is very important. You know, we can really keep away from certain communities. This is bad. Well, usually NGOs are more swift, intervene more swiftly in certain violations. For instance, raiding homes takes place in the mornings, very early hours, and the bar associations are shut, of course, at that hour, so we go. Well, I was going to say something a bit ambitious. If the Diyarbakir Bar Association weren't here, as you know, there is the Rule 9.2, and we are monitoring whether the decisions of the European Court of Human Rights decisions, whether its decisions are being put in practice. And this is important for the following reason. Not only single cases, but cases which act as models for other cases also come on the agenda here. Sometimes in groups, sometimes singly. You can put your view forth on many of these, and there is no limit to this, and you can provide recommendation to the committee. And within the last year, we sent 8 views. One of these files was closed. This had been open for a long time. We were not able to stop the closing of this file. This is important. The more organizations impart their views to the committee on these files, the more impact there is. The Ayatollah A case is one of the cases. This is one of the best practices, and here a fair trial and the support from a council. The European Court of Human Rights found violation in this case. Well, Turkey started a retrial, but kept this person in prison. Well, this is not only the success, due to the success of the NGOs, but in the end, Ayatollah A was released. We hope that we have contributed to this. This was a very new file. Even the government had not yet made its own view known to the committee. Well, let me then sum up in 3 or 4 minutes. Let me also talk about the following. NGOs can intervene in many different violations as a network. Well, this is, for instance, true for the Human Rights Solidarity Network. For instance, there were attempts at repression of the Rosa Women's Movement and others, where we use the United Nations mechanism much more efficiently. And this, of course, makes an impact on the UN if you go there with lots of NGOs rather than one. And in a suicide in prison, we had cooperation with another association. Very little time. Let me give you an example. The violation of rights in prisons. In one case, together with ESHID and many other organizations, a person with 98% disability, a week after their imprisonment, we succeeded in having him sent to a hospital and then out definitively. So this is not something we have not done this very often, but you know, EŞİD uses the relations with the Turkish Equality Rights Agency, TİHEK. When you cannot provide for access to justice domestically, you go outside of the country. For instance, people who ask for asylum, sometimes if NGOs have monitoring reports, and these may be influential on the processing of their files. Therefore, if 10 or 15 years later, a report you have written, you know, is of service, which is great. Thank you. Well, you have really been very careful about the time.
Yes, our microphone is ready for questions. If you want to take the floor, you can. Let us see the hands. I guess the first one was from that corner. Let's start with that one. Please tell us who you are asking your question to. Hello. Your colleague is not a jurist, but the two others are. I don't mind who answers the question. Access to justice for SSP patients. This is a problem for us. And the family is vulnerable. And when somebody dies, you cannot apply after 1 year. And when they apply, Mardin and Diyarbakır do not accept, but Mardin might be so accepting it. When we ask about it, if it has been more than a year since the diagnosis, you cannot apply. And you cannot still apply after a year has passed since the death of the individual. And the costs are paid from our pockets, and we cannot have access to justice. How can we do it? I guess the disease is MS. I'm not 100% sure. And let me address the question to Diyarbakır Bar Association. So there will be the multiple bar association system which will be formed. It might be going slow, but we will get there. I have something in my mind. There are favorite citizens in this country, and the citizens are in general afraid of the state. So in time, we might have favorite bar associations, favorite foundations. So if the citizen does not get a lawyer from that favorite bar association, is there a possibility of his lawsuit not being handled carefully? Or can he think about not being treated fairly? Would this hinder the practices of the bar associations in the long run? Thank you. Thank you very much. First of all, thank you very much for your presentation. In access to justice, we are seeking a fast and effective solution. We have to make presentations that are real and that are justifiable. In this concept of justification, what I understand from today's presentations is that presentation of evidence is of utmost importance. And in the definition and in the management of the process, there are elements we have to pay attention to. so that we can have access to justice. So what should we do in that regard? And I am a forensic medicine specialist. I have been working for the last 35 years, error analysis and access to evidence, and making access to evidence easier should be there. And we have to develop our thinking in an attempt to comply with the standards. And when I think about making an error analysis, we have to first understand that there is an existing situation. Above it, there are processes, and in the processes, there are things that might not go as planned. There might be neglects, for example. And when we are developing our position, we have to analyze the impact of that error. We have to perform a root cause analysis, and we have to make a threat analysis. At critical checkpoints, we have to analyze the dangerous conditions and report them. Such identifications need to be made so that we can go to conclusion from evidence. And in an attempt to minimize the controversial situations, we have to have quick access to this evidence in a standardized manner. Then we can develop a shared opinion on our way to the conclusion. And there is an interesting example. Maybe the president of the Diyarbakır Bar Association can cover this. In fact, mine was not a question, but concerning the question about the favorite bar associations, I might ask a question to Nahit. I know that he's not a favorite. And legal aid payments, you said that they are distributed to the bars in an unfair manner. Can there be a similar practice, like allocating less to bars that are not favorites and allocating more to those who are favorites? I am a lawyer at the Ankara Bar. I also work as a journalist. And lately, at the prisons, we have torture being discussed a lot, and it increased after 2015. In the prisons in Afyon and Antalya, we hear that there are many torture practices. And I have a question to the Antalya Bar president. We have never heard about a torture report from your bar. However, most of the rumors are from Antalya prisons. Why don't we hear anything from them? I see another hand. And I thought strategic litigation would also be questioned, but there are no questions so far. About legal aid, I have a question to Nahit. People who are rights advocates and at bar associations who engage this activity. I'm asking this as I don't know anything about it. If the allocated budget is used and finished mid-year, is there any additional budget that is provided for such activities? One more question from this side. I have two questions to the presidents of the bars. When it comes to legal aid, how is this allocated to the bars? Can you elaborate on the details? And the second question is to Kasım. Actually, I'm trying to ask for Kasım Bey, how do you identify strategic cases as people working at the bars? And Yale explained that they are doing cause litigation. So what do you pay attention to in your cases at your own bar associations? In strategic litigation, it is the potential of being it converted to jurisprudence. Are there any other questions? I guess we are done with the questions. Then let us start with you. Thank you. I apologize for interrupting. The main criteria is the possibility of jurisprudence. And we also look at its importance. And if there is a significant violation, an individual violation, we do not exclude that either. On the other hand, concerning the question of our journalist colleague, Antalya Bar Association Human Rights Center prepares reports, and these reports are quite comprehensive, and they are in harmony with international standards. I can share these with you. However, the management of the bars do not have the authority to publish them, and we cannot provide suggestions. But we do not want to get into a conflict. Our main concern is to build capacity, and the Bar Association is a public organization, and we have to use the advantages. At our center, we have the victim, and we should have the most effective means to help the victim. I cannot say that we get results for all the cases. However, lately in Antalya, it increased significantly, and because of the new institutions that are in play, there are significant rights violations, including torture, and we are aware of this. And you should also know that we are handling all these cases free of charge, and we try to allocate time from our daily professional activities. We don't expect anything in return. Geographically, Antalya has districts that are quite far from each other, and if you want to go to the town of Alanya, for example, you have to cover 400 kilometers, for example. And we are not the only office that has a human rights focus. Human Rights Foundation of Turkey also has an office. We usually make consultations, and the only difference we have is that we prepare more comprehensive reports. However, their activities are very important, and I respect their sacrifices. I cannot defend our limitations. However, we try to surmount the limitations we have. We have not a near-term, but a long-term approach. So we shouldn't lose the potential we have. That's the main priority. Regarding the patients you asked about, if we talk about access to justice, we are talking about the right to a fair trial. Right to a fair trial does not guarantee us a result. It only provides us with the procedural guarantees of the process. Yet the fight is very important, and this needs to be brought to the agenda. You are talking about a problem that deserves a fight for human rights. However, this is about a process, and judicial mechanisms do not have a human rights focus. They do not prioritize justice. I believe it was Orhan Gazi Aytekin. He said there is no justice in Turkey, there are only courthouses, he said. So we are going through such processes, and this fight needs to get bigger, and you have to be part of it. Our main function is to support you. And from this perspective, on behalf of my center, I can make the promise that we can provide you the information support that you require. However, in your neighborhood, you have the Diyarbakır Bar with vast experience. You can easily ask for their support as well. In law, sometimes time can create an obstacle in front of access to justice. And I do not know anything about the details, but you cannot do much once that time period elapses. However, this is not something rigid, and there are many examples of jurisprudence that is accumulating in front of domestic courts and European Court of Human Rights. If there is an obstacle in front of access to justice, this creates a problem, and this should be evaluated on an individual basis. Unfortunately, I cannot hear the person asking the details. This is a technical topic. Let us talk during the break, the moderator says. So, as the president of a bar association, that is not a favorite. I actually sensed this during our trip to Bartın yesterday at the restaurant. And I thought Ankara governor's office might ban this very activity. Regarding the budget for legal aid, legal assistance, for example, we are now talking about the budget for 2022. This is 2,175,000 liras. This is based on the figures of 2020, and based on the 2% of all the fees, they identify a budget. I became the president of the bar in 2020, and the budget I had in 2021, as no lawsuits were filed because of the pandemic, the fees were very low and the budget allocation was low. And then your legal aid allocation gets very low, and sometimes it can be very high based on the number of lawsuits opened. For example, in 2021, the number of files were high, so our budget for 2023 can be higher. So they do not pay attention to the number of applications from that location or their socioeconomic status. Every bar association is assigned 5 points. Every 50 lawyers assigned 1 point, and then the population 1 point. And based on the identification of scores, you have your share from the budget. There was a question about the independence of the bar associations or independence of defense. Yet for Istanbul Bar Association and Ankara Bar Association, the situation is very grave. For those bars to be established, there were 2,000 lawyers. And I had mentioned this in a meeting of presidents of bar associations where Kasım was present, and the average age of lawyers is very high. Most of these people are public lawyers, and the young lawyers, number of young lawyers is low. In order to make these bar associations attractive, they made this amendment. And in Istanbul, they changed the way legal aid is allocated. and they allocated equal amounts to two bars. For example, in Diyarbakir, this bar association has a history of 100 years, and we have 2,500 lawyers. But in Istanbul, they don't have even 100 lawyers with a human rights focus, yet their budget is higher than ours, which creates a real chaos. We submitted our objections. However, the ministry did not listen to our complaints. And number two, bars became a center of attraction for the reason I mentioned. When you use your allocation and when you finish it, do you have any extra payment mid-year? No. You have the payment in 4 equal installments during the year. So, Provision 1 of the attorneyship law defines us. We are freelance lawyers representing individuals. And today we know the rules for employment as judges and prosecutors. You have to get a certain score out of a test. And imagine that the lawyer has the power of the lawyer represents you in a case, but this is an area of problem in the judiciary, and the citizen thinks that should I go to the second bar to get a lawyer, for example. In my bar, the transfers are difficult. Number 2 bars became a center of attraction to be a judge or a prosecutor. If I am registered to the second bar, it might be easier for me to get to this position. These bars, unfortunately, are closer to the government, and there are injustices. And on the issue of supremacy of law, we can talk for days in Turkey. Among those who have been to Amasra, so we can see the differences, and it was as if I attended and they were criminalized. So there is no practice there, and the fight with inequalities brings about the experience. In Ankara, Istanbul, and Izmir, for example, the situation is different. For example, yesterday I had to apply to the administrative court through the UYAP, the online system. And I wanted people to open that lawsuit. It is about entering a certain province and the ban to do that for 3 days. It creates many rights violations, and the decision is not acceptable. Some told me that if it gets longer, we can apply. But if this is not cancelled at the administrative court, then it can be brought to the European court so that the others should not be encouraged to come up with a similar measure. Number 2 bars and their position in front of the citizens and the imbalance that is created by their presence. Our forensic medicine expert talked about the evidence. Evidence is very important. Before elaborating on the evidence, so how do we identify strategic litigation? In legal aid, I told you that there were 2,900 applications to the Diyarbakir bar, but we could handle only 1,090. I'm correcting the figure. And these were mainly divorces and domestic violence, and women were prioritized. That's the strategy we have. We want to prioritize disadvantaged groups, primarily women. And In the strategic litigation that Diyarbakır Bar handles, for example, in Trabzon, Metin Lokumcu or Deniz Poyraz cases, these have importance in the public, and these are for supporting our colleagues. And in 1990s, there were grave human rights violations. Those cases, you all know that these are about people who are transferred to western cities of Turkey. And Diyarbakır Bar usually handles such cases, Roboski case, Şen Yaşar case. Our main strategy is to prioritize those lawsuits. It has to serve the common good. In the region, so there are centers that operate like a bar. And what we felt is that these human rights centers need to be established at all the bars all over Turkey. When I was talking with the prosecutor in Bartın, I said that you have conducted a reconnaissance. However, have you obtained a video recording? He said that we are keeping records of this, but with the developing technology and with a new witness testimony, you can obtain new evidence from the initial appearance of the crime scene. I told them to have recordings. In the Tahir Elçi incident, all the video recordings were obtained, and Republican prosecutor did not listen to anyone, and those video recordings were sent to London, UK, and in the studios the images were synchronized in an attempt to identify which bullet and which weapon was used. And the identification was made, and they told us that it is one of the three of the police officers who shot him, and the others were no longer suspects. In these type of strategic cases, at the moment of evidence collection, we need skills, and the slightest detail can easily shed light into certain murders. I guess I covered all the questions. Thank you very much. Thank you very much. I'm closing the session, but I believe there will be a closing session, and our organizer colleagues told us that we shouldn't give a break. If it is appropriate, it will be immediately after this one. I would like to invite our moderator.
The session is over.
Evet, öncelikle sabrınız için teşekkür ediyoruz. 2 gündür oldukça yoğun bir program vardı.
Agenda for these 2 days, and your contributions were very valuable. We said that it will be the closing. However, I would like to make an introduction. In the end, all the activities and serve the purpose of cooperation and solidarity. And concerning the access to justice of disadvantaged groups, different actors need to be here and be in solidarity. I am introducing people for the last 2 days. Let me introduce myself. It seemed as if I only have the academic had, yes, I'm an academician and I'm part of the legal education. But on the other hand, since 2013, I'm a member of the Association for Monitoring Equal Rights. And because of this attorney situation, I am a member of the Ankara Bar as well. So there are many aspects. So I want to see this as a start, as a beginning, as has been mentioned and underlined in many presentations. We have to make each other stronger and we have to collaborate. And so the spirit of the time, my colleague said, that is difficult. And the concept of justice for us is an area of struggle which is getting more difficult to navigate. And in Turkey, as has been mentioned, we have human rights activists, and on such activists, on lawyers and on bar associations, we have violence, and we have presidents of bars who have been victims of violence. There is significant pressure, so the cooperation and the collaboration, solidarity becomes even more important. About Turkey, the most important political agenda is justice. And we always follow up cases, and every day is spent by the injustices that take place. And that is why we have to focus on what to do and how to do it. That's why we wanted this to be a forum. But I will try to cover the main headlines during these 2 days. Maybe you haven't participated in all of them. And in all the sessions, we focused on access to justice. We have different groups, different needs, and naturally different types of discrimination that takes place. And as we fight with these, we all learn things. And so there might be things we have not covered, or there are things that we don't think about, and it is an opportunity for us to learn about this. Access to justice is a key to have access to other rights. When you do not have access to justice as a group, then it becomes impossible to have access to other rights. And at that moment, the obstacles in front of access to justice relates to racism, discrimination, and the increase in far-right governments. And legal aid was a topic that we discussed. The reason for us to cover legal assistance was that worldwide poverty is on the rise, and there is an inequality in the distribution of wealth. And migratory movements, climate-related migration, and war and conflict-related migration is another agenda that we have. And poverty, inequality, and there are problems related to education. And there is not much right-based approach to solve this. And accessibility is a priority. Of course, we cannot claim to cover everything at this conference. There might be many points to be prioritized, and we can be criticized, but there were things that were impossible during these these 2 days.
Another topic that we need to take up, and this was taken up by almost all speakers, the place where human rights and justice have come makes this all the more important. Starting with topics on judiciary independence, the barriers, in particular the emotional barriers with respect to the justice system, and other kinds of litigations or proceedings that totally question the question of impartiality makes this very important. There are these negative experiences really make this a big question. I said a holistic viewpoint. Of course, I am outside of one of the factors, the state. We have not been able to talk about the state much, but there is the central administration and local government, which is also part of it. We need to touch upon those as well in the future. But we cannot, really help with what's happening there. But, we will make do with our own positions. What can we do is critical. I wasn't able to touch on this best practice yesterday. There is there was a question on the Center for Persons with Disabilities of the Ankara Bar Association, and there was a workshop that was organized some time ago, and then there was the whole pandemic period after that. We made training available for the rights of disabled people. Then the people who receive the training are appointed to positions that are relevant to this area. But then the Bar Association has other instruments, but then there are limits there too. We talk to the Ministry of Justice and the Ministry of Social Work, and with respect to the interpreters of sign language, there was a discussion, but we didn't advance much. With respect to the to law education, we really have a limited impact with our clinics. I think, these centers of human rights are schools for human rights, and the question of what we can do together, the civil society, bar associations, with respect to the centers on the rights of the child, and then women's centers for women's rights, the inclusion of these groups who have special problems is good, of course. But these groups, of course, are subject to special kinds of discrimination. But then, litigation may become risky in these cases. Profiling, of course, is a part of this. There are also recriminations and other kinds of threats. I thought the Diyarbakır Bar Association would talk about this. I would like to say something on the Diyarbakır Bar Association. The reporting, when I talk about the duties of the bar associations, the report of the Diyarbakır Bar Association on the women's question was very, very important. Bar associations have a very, very important role to play, and they, don't really realize the importance of that work. And I think, this capacity will be increased by their work. Well, human rights are for everyone. Yes, all of us together should work for this. We need to produce new instruments for this. I do hope that we will create new environments and new instruments. Now I will invite now Zekiye, the president, the chairperson of ESHID, the Association for Monitoring Equal Rights, and then we do ask you to pose questions. This is, I hope, not a closing, but a beginning. Well, I'm losing time because I have to adapt. Well, and I, cause you to lose time. I'm sorry for this. Dear Chidem, you really summarized everything very well. What remains for me is to to present the thanks. Now, let me start with to the European Union Turkey delegation, our partners, Atılım University and the Union of Bar Associations of Turkey. Well, start from the beginning. Okay. I was not able to, disconnect myself totally. Okay, I will start again. First of all, our thanks go to the EU delegation, Turkey delegation, for having made this conference possible, the Atılım University and the Union of Bar Associations of Turkey for having partnered us. Banu Türkun Şahin, Kadir Demir, Berrak Fırat, Hasan Pikiva, Esa Karada, Serra Aytekin are the translators whom I would like to thank. They made communication possible. Of course, our interpreters from English into Turkish and Turkish into English, Şule Girmen and Sungur Sayban, I would like to thank them very much. Their contribution is great. The whole interpreters team. To the technical team who has facilitated our work. In the preparation of and execution of this conference, our project team, Egem Tourism for having contributed to the organizing of this conference, to the speakers and the moderators, in particular the speakers, for having shared their work and their thoughts with us. Again, well, and most important of all, to our participants who have not abandoned this hall for such a long time during the 2 days. We need a mic for, the participation of our guests. The floor is yours. You will be on the stage now, so to speak. Well, the bar associations in the legal aid centers there is a kind of tendency of lawyers to refuse the demand that comes to them. What can the Union of Bar Associations of Turkey do to put this right? On the question of legal aid, there may be situations where the people in charge of these centers may be appointed. There are certain very specific files that may be taken care of, and the councils should be experts in these areas. But on the other hand, it's as if we were, breaching the rights of the lawyers. What can we do? Well, I have entered some of the centers of legal aid because of these legal clinics. All bar associations have different tendencies, and their perception of the question differs over time. There's a problem there because one needs to be flexible with respect to a criterion of poverty. There are times when a document for poverty is sought, times when it is not. Well, go ahead, please. Well, let me say the following. Chidem said it. Each bar association has its legal person, and the union is an organization of the bar association, but there is no hierarchy. It cannot really give instructions to the bar associations. The criteria for legal aid, everyone is aware that documents are sought for. And in the Union of Bar Associations, the colleagues on the Commission have made some research, and it will be, written to the Bar Associations. It has been apparently written to the Bar Associations what should be done, and attention is being paid to the possibility of these documents to be obtained from the internet, from the e-state website. But, there is no hierarchical relationship between the union and bar associations. Well, the applications of LGBTI individuals, there was a different kind of practice in 2017. I was doing work on the systematic of the criminal code. Perhaps we should talk about the types of cases here. For instance, when it's a question of crime, of hate crime, then this is critical. One can say this very frankly here. There should be no risk of the lawyer taking a discriminatory position themselves. Yes, please go ahead. Hakan Tahmaz is my name. I am on the board of the Peace Foundation. I work on conflict resolution. This is my second meeting with you. I was very, very pleased by the whole conference. One thing that I was very impressed about was the presence of women on the stage. I have two proposals to make. One is short-term, one is long-term. Now, within the scope of access to justice, what kind of new problems do we face with respect to access to justice after 2014, or even more so, even after 2017? This presidential administration system, what impact has it had on access to justice? There are elections before. There'll be a transition or not is important. Perhaps this should be also worked upon, and an original kind of system that exists now compared to the past. Perhaps this could be brought out. The president of the Bar Association of Diyarbakir talked about this. Turkey has a big problem in the access to justice. There are many common problems in Turkey, but then there are specific problems to regions. I was both tried in Istanbul and Diyarbakir. There is a great gap in the Kurdish region. The functioning of the judiciary is really problematic. The association, if the association takes this question up, it'll be very useful. One more recommendation. Lawyers who defend the law, justice, come together in national congresses of bar associations. This happened in Istanbul yesterday and Izmir. This is just a wish. There are people who work for bar associations here, but you said, are lawyers making discrimination? Do they make others, people into others, turning them into others? So that is a question which is bad, that it should be taken up on itself. I congratulate you. Well, we have received many recommendations. Perhaps strategic litigation is another duty that we could take up. Well, the specificity of the post-2017 period. Our guest was talking about the General Assemblies of the bar associations. We have had these problems before, so this is the problem that our guest has raised. I wish we had some impact on the bar associations. Yücel Tutal, the Association for Roma Rights, thank you for the event, for the organizing of the event, for those who have worked to organize this. As someone from the Roma Rights Association, I would like to say things about the Roma rights, but when we take a broader viewpoint first, we talked about access to justice. We really talked about the legal aspect of the question. The Diyarbakir Bar Association also mentioned this. We all have duties to provide for access to justice. And Mark also mentioned this. There are lots being done, for instance, in England. In Turkey, there is so much to do. Both NGOs and bar associations, our judges and prosecutors, the disadvantaged situation of the Roma. They talk about this, but there are no solutions proposed. Of course, we also criticize ourselves as Roma NGOs, as Roma activists. We question ourselves, but you, well, I say you because I'm a Roma, you should also question yourselves, lawyers, bar associations, activists. For instance, how many people know about the Sevendi events? How many people know about the İzmit case, Caner Sarmaşık case? I don't think there are very many people here, even if they are members of bar associations. This also shows how honest we are. Perhaps I'm talking a bit too harshly, but we don't have, clear opinions. We are not, pressured under the public opinion. We don't receive any media support. We don't receive any support from the lawyers. Very few organizations help us. One of them is EŞİD. Please don't take it upon yourself. But there are many things that are missing. In many presentations, it was said that the Roma were one of the most vulnerable groups, but there is no work on this. I think we are the most disadvantaged group after the LGBTQI individuals. They have an advantage. They are more conscious, self-conscious about their interests, but in the case of the Roma, no. When we asked the society at large, what do you think of when we say Roma? You think of entertainment and dancing and all that, but the Roma are always part litigants. We have such prejudice against the Roma that, despite the fact that we have been attacked so much, how many cases are we part of? This is very strange. Because of the fear of going to the police precinct, because of our fear of courthouses, we really do not go there. We, as the Roma NGOs, bar associations, NGOs that work in strong altogether. I'm going to make some self-criticism. Well, EŞİD really monitored all the cases, but it's not very strong with respect to memory work. We should bring this in front of the public, before the public, and we should be reporting on this for the future. Yes, go ahead, please. Hello, Professor Çiğdem. Civan Aslandaş is my name. I have a question. The method of work of the clinics and the scope of the support of these clinics. Would you please speak a bit about these? This is something that was established at Anadolu University, I think, and legal information was provided to the public. If this is wrong, would you also speak about the different instances? And if this is taught by students, does this cause a problem with respect to Article 35 of the law on lawyers? And how can this kind of practice be spread even farther afield if this is useful? Thank you. I worked 1 year to convince the Bar Association. I invited them to our meetings. When Erinç Sakan became the president of the union, we started to talk about this. The students go to bureaus of legal aid and prepare reports. And in another branch, we prepare reports for the Ombudsman. I can make a call to NGOs in Ankara. We want to work more actively in this field as NGOs, but because of the pandemic, we have delayed our calendar a bit. One of the first instances was the Istanbul Bilgi University, and I really also made a mention of Kasım and Kıvılcım. They gave us a hand to Anadolu University. With NGOs, we want to support them for strategic litigation. We did not do any rights education. Another colleague at a university did this, and then there was training for university students. Let me say something on discrimination. Well, there was a criticism. Can there be discrimination among lawyers themselves? Yes, of course, human beings can err, but I think that the practice of policy implementation documents which were adopted by many bar associations, and this is serious. There are mechanisms that are imagined in that report, but because of the electoral process, we could not complete this. You're making me talk too much. I want you to talk more. No questions, huh? Well, you're tired. We took duties upon us. Thank you for your participation, and see you.